Yes. What is this about? That is what is the offense involved?
No, my offense is my NDPA. Section 20, my lord.
Under section? Under section
Section 20B.
21B,
20,
20B.
20.
Yeah.
20B, my lord.
Already filed.
Owner is approaching. Sorry,
Hmm?
Owner of the barricade that has been seized that in connection with that PS, no,
Hmm.
my lord. So owner is approaching.
Okay, you have already filed.
Issued to him appear to
Owner was not present in on the spot. Okay.
he
Whether you have already filed.
already.
Okay, let us see. Hmm.
Your Lordship, I beg to mention item number 26. I mean, appearance of Senior
26.
Deep Pangi. So kindly this will be fixed on 16 September.
16.
September.
26.
Yes, Your Lordship.
Uh,
I am for the respondent.
Respondent, have you informed the appellant? Counsel for the appellant,
Yes,
Mr.
Sita Jo.
Tajo, Land Council appearing on behalf of Mr. Deepang with the consent of the Land Council appearing on behalf of the appellant. Prayed for listing this matter on 16th September. Stop the prayer is allowed.
Your Lordship.
List it
Also-
accordingly on 16th.
Also, item number 29.
29 also.
Hmm.
Okay. And here, have you informed the other side?
Yes, I am in this matter. I am for the petitioner.
You are for the private respondent. Okay. Mr. Titajo, Land Council for the appellant. Tajo submits that. This matter one to be fixed.
This 16 September. This
16.
Hmm.
Tajo submits that on the Mr. Tajo on behalf of appearing on behalf of Mr. Dicky Pange, Land Senior Advocate for the appellant. Praise for listing this matter on 16, to which Miss Land Council appearing on behalf of the respondent has no objection. Accordingly, the prayer is allowed. Please take accordingly on 16. Okay.
much of less.
May I please, Lordship?
Hmm.
Lordship, I like to mention item number 23.
Item 23.
Yes, Lordship. Matter is called for the TCR by this honorable court. However, the TCR is still awaited.
This is for order. Wait for some time. Let us see.
TCR is still awaited, Lordship.
Okay, let us see records. Then in that case, in order, all will be adjourned only. In the okay. In the mention. Yes.
Lordship,
The
I beg to
mention
mention-
state will not pass any order on order. Yes.
Lordship, I beg to mention item number 6.
6.
Yes, the leading counsel is out of station, so this matter may be fixed on 3rd September.
When?
3rd September.
3rd September.
Yes, Lordship.
Okay. Mr.
Titechi.
Land Council submitted the conduct Mr. N. Rama, Land Council, the conducting council for the petition of Mr. R. Nabam is out of station. Therefore, pray for praise for adjournment of the matter for the day and to be listed on when
3rd
Third.
September.
the prayer
Lordship,
having
there
not
is an
been
interim.
objected is allowed. Stop. Listed accordingly on 3rd September.
There is an interim, it may be continued.
Okay. It's a criminal petition contested. Have you informed the other side? There is a private respondent. Private respondent. But not in this. Okay. Let's pray for comma. This is accordingly on 3rd September. Yes. The interim order passed earlier shall continue. In there.
Much obvious.
May I, Lordship?
Yes.
Lordship, I would like to mention item number 28. I'm for the victim. So I've taken concern of from the petitioner also.
2-8.
28 for hearing, Lordship.
Yeah.
This matter may be taken after 3 weeks, Lordship.
After 3 weeks.
Yes.
Why?
Sir, Lordship, we are not ready with
Okay. Mr. Jamo, B. Jamo, Land Council appearing on behalf of the respondent. Submits that he is not prepared to therefore pray for adjournment. He submits that he has also informed and obtained consent from the Land Council for the appellant. Staff is prayed for comma list the matter after 3 weeks. No.
deeply of life.
May I, Lordship?
Yes.
Lordship, I want to mention item number 27. Lordship, our leading counsel is out of station.
No, not. Have you informed the leading counsel for appellant?
Yes, Lordship.
Okay. Have you informed the other
Yes,
side?
Lordship. Yes,
Informed?
yes.
Okay. Mr.
M. Lolan.
Land Council submits that the leading counsel for the appellant is out of station, therefore pray for adjournment. Stuff he
Matter can be listed, Lordship, after 3 weeks.
of the matter for after 3 weeks. He
Yes, sir.
submits that he has also obtained consent from the Land Council appearing on behalf of the respondent. Staff has prayed for comma list the matter after 3 weeks. Okay.
Much obliged.
Maybe, I'd like to mention item number 11 and 12.
11.
Yes, 11 and 12. But on behalf of Opata, special people, special public solicitor. Special public solicitor for the ACD.
You have informed.
Yes, ma'am.
I'm for the applicant, Your Honor.
You're for the
Applicant.
and you are for? You are for respondent.
Behalf of Opata.
Okay, Mr. You are Mr. Land Council. What happened? But I out with station. Some misters, the,
May I please, my lord? My lord, a
Yes.
fixed date may be given. It may be fixed on 7th
okay.
September.
So this is in order. Since we have received the A star, we will fix it for admission.
Yes, ma'am.
Okay. Some is that, the standing council. Standing council for SCB, Mr. Opara is out of station, therefore praise for adjournment. So Miss
M. Karwat.
Land Council for the petitioner has no objections. However, she prays that a fixed date may be given. Staff has prayed for comma list the matter again on when
7th of September.
7th. 7th.
7 election petition is there, Lordship.
No, not on 7. After 7.
7, 8, and 9 is difficult.
Okay, we'll
8.
fix it on
8, my lord.
8. Yeah.
8 also there, but it's okay, Lordship.
Okay. Covered. Then, okay, 10. Okay. For admission.
10, Lordship.
Okay.
Obliged.
Item number 1.
May it please your lordship.
Yes.
This is an bail application in connection to Teju PS case number 09/2026. The accused is charged under section 69 and 115, clause 2 of BNS,
What is 69?
false promise of marriage,
Okay, what is 115? Two.
voluntary causing hurt.
Okay.
Your lord,
When he was arrested?
he was arrested on 23/7/2026,
Okay, what is the punishment for 69?
10 years.
Hmm?
10 years.
10 years. It's a minimum or the maximum? Is there any minimum?
Mhm.
Yes, who appear for the state? Okay. State, no one appear. Full issue notice. Okay.
CD may be calls.
Yes. Miss
C. Sira. C. Sira.
C. Siram, Lana Council for the petitioner. Who filed this application? Accuse himself or someone?
Applicant.
Who is the petitioner?
His brother.
The
Deepak Seni.
decision, this application has been filed by the petitioner, who is stated to be elder brother of accused Amit Saini, under section 483 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for release of the accused who has been arrested in connection with Teju PS case number 9/2026 under section 69/1152 BNS 2023. Stop. Then include El Hage names. Also had Miss El Hage. Then additional PP for the state. Okay. Then issue notice. Since Miss El Hage, then additional PP could appear and accepted notice on behalf of the respondent. No formal notice need be issued. Stop. Call for the scanned copy of the case diary. Case diary charge sheeted or what? It is still in
No.
investigation stage.
Yeah.
Whether the case has been charge sheeted already? Not yet. Okay, call for the scanned copy of the case diary. Stop. List the matter. When? Next week?
14.
14? Okay, on 14th.
Right.
Item number 2.
May I please?
Yes.
This is a regular bail application under section 483.
It may be passed out for timing loss if he is appearing in this
But
matter.
today only notice will be issued.
We'll call for the case diary.
Yes.
What is the offense?
The NDPS,
NDPS 21B.
20 and 20.
Okay. Mr. Disoki, planning counsel for the petitioner. Also had Miss El Hage, plan additional PP for the state staff. Who is this applicant?
Applicant is the wife.
Okay, the applicant who is stated to be wife filed this application under 483 of Bharatiya Nagarik Suraksha Sanhita, praying for grant of bail to the accused. What is Osina Chautang,
Osinacho.
alias Wasina, who has been arrested in connection with Namsai PS case number 51/2026 under section 21B/29 of the NDPS Act. Stapa. Issue notice since Ms. Elhage appeared and accept the notice on behalf of the state respondent. No formal notice is required to be issued. Staff call for the
Scan copy.
scan copy of the case diary. Staff case diary still under investigation.
Under investigation.
Okay, list a matter after a week.
Six step.
Teju
Namsai.
or Namsai.
Namsai.
Next week
Next,
or when?
next week, any date? 11,
11 to Friday again.
11 by this only available.
14th.
14.
Okay.
Item number 3,
Public.
Yes.
May I please, my lord? This is bail application number 116 under 482 of BNSS. On the last occasion, my lordship, BA was withdrawn and this is a fresh bail
Okay,
application.
okay. You have filled up and there is no criminal antecedent against him.
Yes, my lordship.
Okay, what is the offense?
My
registered
lordship,
against accused?
my lordship,
74.
yes, my lordship.
What is 74?
Outrage of modesty, my lordship.
352.
Intentional insult to provoke breach of trust, my lordship.
And what is this 34(7) of Police Act?
Public nuisance, my lordship.
Whether the accused is in service or what?
No, my lordship.
Hmm?
No, my lordship.
Not in service.
Simple farmer, my lordship.
But the allegation is serious against you, although the case registered against you is not, doesn't seem in consonance with the allegation.
Yes, my lordship.
And the bail, your bail application moved before the session court has been rejected and with the direction to surrender before the eye of the case.
My
But
lordship,
instead of surrendering, you have come before this court. How do we reappreciate once the pre-arrest bail has been rejected on merit with such observation? How do we reappreciate? The allegation also seems serious.
my lordship, if my lordship may kindly take into consideration that the petitioner is engaged in the medical treatment of his wife, who is currently under serious.
But the Lani court says that the wife was also present before the court. She stated before the court that she can sit, stand, walk without any help. She is hale and hearty. Have you seen the record? The order?
Yes, my lordship.
So,
My lordship,
wife is not connected.
she is, my lordship, the council has submitted annexure number, annexure number 5 series which states that she's under medical treatment, my
Who?
lordship. The wife, my lordship.
So what? Wife is not accused.
Yes, my lordship. But
Hmm.
the
Wife will go for treatment. Son, mother will go. How it is connected with the accused?
my lordship, the applicant is the sole breadwinner of the family, my lordship, and he is the only sole supporter right now who is currently engaged in the treatment of his wife, my lordship.
Then he should not have committed this.
My
Such
lordship,
offense.
the offense mentioned in the FIR are concocted and falsely fabricated, my lordship. It was a preemptive.
Now how and why the victim who has been injured has been sent to the hospital, Tomoriba? And how many persons have been alleged against you? 1, 2, 3, 4. 4 persons. Who assaulted your wife, you said?
One named Raju Soja, my lordship, who is the
Hmm?
son of the complainant of the FIR annexed as Series 1, my lordship, page 16.
Page 16.
Yes, my lordship.
No, page 16 is FIR against you only.
Yes, my lordship. The complainant Kakap Soja is the mother of Raju Soja, my lordship, the one who assaulted the applicant's wife, my lordship.
Okay, where is that FIR?
It is annexed as series of 4 series, page 20, my
After this incident, Kakap Soja's son assaulted your wife.
No, before, my lordship. Prior to the FIR dated 18/08/2026, there were two
Okay, son of
FIRs.
Kakap Soja assaulted your wife.
Yes, my lordship.
Okay, this is revenge.
Yes, my lordship. They have filed for the FIR and simply lodged the FIR to suppress the prior FIRs which were in existence, my lordship.
But then you have coach see page 16 and serial number 3 Kakap Soja's what injury she received. Have you seen? Injury number 1, physical assault and severe torture. And next, page 16. Have you seen?
Yes, my lordship.
This is a serious allegation. This is different.
My lordship, this is completely false and fabricated, my lordship.
But then she has been forwarded to the Tomoriba hospital. And then the Lana Session Court also. Made an observation. Para, page 23. Which she had been referred to the TRIMS, Nahalagan, for immediate treatment. Yes, Miss Jenny, what can we do?
Your Lordship, I'll just clarify that if Lordship come to page number 23, Your Lordship, with regard to all the FIRs,
Page 22
22, Your Lordship,
is order.
is the order, Your Lordship. I'll just show the investigation done, Your Lordship. If Your Lordship read the last stanza, last paragraph, Your Lordship. The alia of the case who is present before the court in person while submitting his CD and status report has apprised the court that as per his investigation till date, he has not found any direct link between the FIR dated 12/8/26, it
Okay,
is
FIR closed by the
Y,
accused. Okay.
and another FIR dated 16/8/26, that is the FIR lodged by the accused in one hand and the instant FIR of the instant ABA on the other. So all those FIRs that which is alleged to be a counter FIR, Your Lordship, that those two FIRs does not have any link to the present FIR, Your Lordship.
But then you can see the space. Okay, where is your FIR lodged by the wife,
Lordship will find at page number 29.
29. This was on
It was, the incident happened on 9/8/26. She filed the complaint on
9/8.
12/8/26.
That
The incident
it
happened on 9/8,
complaint. This was Lubong.
and this was submitted to the President Secretary. A copy was submitted to the Women Welfare Secretary. And this has not been registered, and we are not aware of what
On
is.
the approximately will have to ascertain this. According to her, this FIR, this assault was by one Raju
Yes.
Soja, and then this Raju Soja is son of the informant number 3, Kakap Soja.
Yes. And we are not aware of
Hmm,
that.
so
There is no document to show that.
let us
Otherwise,
see.
yes,
Call
otherwise,
for the
yes, your Lordship can call
case
for the
diary.
CD, your Lordship.
Hard miss
Tana Opo. Huh?
Tana
Opo.
OPO
OPU.
OPO
You, my
OPO.
lordship.
Okay,
Yes.
OPO. Learning counsel for the petitioner.
May I
Uh,
please the lordship, the council's prays for the interim bail till the time CD may be called, my lordship.
I have heard it. Okay, also heard Miss Jeannie, Nana additional PP for the state staff. Huh? By filing this application under section 482 of the Bharatiya Nagarik Suraksha Sanhita 2023. The applicant is seeking pre-arrest bail, apprehending his arrest in connection with. Where is the PS case number you have mentioned? Sijosa PS case number 9/2026 under section 74/352 BNS read with section 34(7) of Police Act 1861. Start. Para. The allegation against the accused in the FIR dated 18/8/2026 is that he has assaulted, physically assaulted and caused injuries to 4 persons who are informant. But the allegation is serious here. Uh, Informant based on which The aforesaid police station case has been registered. Stop. Huh? Para. Earlier, the bail application moved before the session court for grant of pre-arrest bail has been rejected on 25/8/2026. Stop. Huh? The non-counsel for the petitioner submits that prior to the present lodging of the present FIR dated 18/8/2026, the son of the informant Kakap Soja, namely Raju Soja, physically assaulted the wife of the accused, for which a written complaint was lodged before the officer in charge, Joseph Police Station. And due to the injury sustained by his wife, the wife is under treatment and no one to look after. And since the accused, since the applicant is the only person, only the sole breadwinner, there is no one to look after his wife. Stop. Huh? The learned counsel for the petitioner also submits that the accused is ready and willing to cooperate in the investigation and to abide by any condition imposed by this court for his bail. Stop. Huh? The additional people opposed the interim prayer, a grant of interim bail to the accused. On the ground that his anticipated bail earlier filed before the session court was rejected. Stop. Huh? Para. Also, the scanned copy of the case diary. Upon hearing the parties, this court is of the view that the case diary need to be perused before consideration of the anticipatory bail. Accordingly, call for the scanned copy of the case diary. Stop. Huh? List the matter when?
On 10th, Your Lordship.
10th.
Or on 9,
Hmm?
on 9th,
Which-
Your Lordship.
Which PS?
Sejusa, Your Lordship.
We'll fix it on 14.
14. Your
Okay,
Yes.
14. Stop. Huh? In the meantime, till the returnable date, in the event of the accused applicant being arrested, he shall be released on interim anticipatory bail on furnishing a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. In the meantime, they have put one also without considering the matter on the merit of the case. In the event of okay. Stop. on, subject to the following condition. All those conditions that the accused shall appear before the eye of the case. See, the incident took place when? 16. Sorry, 18.
No,
Now also, he has not yet been arrested. It
Yes.
appears that police in the same station.
yeah, there has been a statement given to the magistrate by the police that he has been absconding, Your Lordship.
Okay.
It's in the rejection.
Let
bail
him be
order.
arrested.
Yes,
He will just, he will
Yes.
not come.
yes,
It's always better if he surrender
yes, yes.
or come. Okay. Yeah, appear before the eye of the case within 7 days from today. 7 days, or if it is on 14, then it can be
Within 10 days,
days,
Your Lordship.
within 10 days from today, and thereafter appear before the eye of the case as and when called for. Staff, that the Mm. Mm. Yes. Yes. Mm. That the accused shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case, that we shall not leave state of Arunachal Pradesh without prior permission from the eye of the case. Okay. Mm. List a matter again on 14. Okay.
Much obliged.
Matter number 4.
May I please, Your Lordship?
Yes.
So we are approaching this honorable court by way of invoking section 520 of the BNSS, Lordship. What had happened, Lordship? The Lordship will find the FIR at page number 22.
528, not 550. Mm.
528, Lordship.
Mhm.
Yes, Lordship. What had happened, Lordship, on 26/6/2025, Lordship, the petitioner number 1, Lordship. Petitioner number was 1, he was on his way to Santipur, Lordship, from the rowing, Lordship. In the meantime, what happened, Lordship, in the Mecca Tri-Junction, Lordship, at rowing, Lordship, his Bolero car has had on collide motorcycle,
But the person
died, unfortunately, Lordship.
Okay.
Yes.
The case registered.
Case registered,
Charge sheet
charge
already
sheet has
filed.
been filed, Lordship. And now, Lordship, on a humanitarian ground, Lordship, since they have settled the matter with the wife, Lordship, but the
Compensation also, MSCT also filed.
that part we have no idea, because since the
Okay.
person who was riding a Bolero car, Lordship,
Mhm.
he is also a driver, Lordship. He is also belong from a very poor family, Lordship.
Mhm.
So on a humanitarian ground only, the lump sum amount has been paid to the wife of the petitioner, because the incident, Lordship, itself is, Lordship, is a part of, there's no negligence on the part of the petitioner number 1, because the motorcycle was riding on the wrong side, Lordship, with a high beam, Lordship. And it was at the night time, Lordship. And as per the investigation report also, Lordship, there was a there's a collision which
Let
was.
let us see the record.
Let's,
Okay. We'll call for the case diary or what charge sheet already filed?
charge sheet has been already filed.
Already
TCR.
filed. We'll call for the trial court record then in that case, Ms. Jenny.
Yes, your lordship.
Okay. Because it's a case of death case. That is a little difficult.
There is otherwise already a judgment from this honorable court that in such cases, the settlement should not be considered by the.
That is where, let us see.
Yes, your lordship.
Because here in this case, it appears, as per his, of course, version, or his version of the case, that the fault was on the part of the deceased. We do not know.
Yes, Lord.
Let us see the record.
Hello.
Okay, hard.
Tigaram.
Okay, Mr. T. Garam, Land Counsel for the petitioner. Staff, huh? Pat. This application has been filed under section 528 of BNS, Bharatiya Nagrik Suraksha Sanhita 2023, seeking quashing of the proceeding under GR case number 62/2025 under section. Where is the PS case? Arising out of rowing PS case number 35/2025, registered under section 281/106 within bracket 1 of the Bharatiya Nyaya Samhita 2023. Staff. Mr. Genie, Miss Genie also, huh? Additional BP for the state staff. Issue notice, since Miss Genie would appear and accepted notice on behalf of the state respondent, no formal notice is required to be sent. Staff. Call for the scanned copy of the case diary, not case diary. Trial court record from which court you said?
That's a CGM rowing, Lord.
Okay, then in the beginning, in that above, under section so and so pending before
CGM, London
the
trial
court of
proceeding.
chief judicial magistrate drawing.
Rowing, Lord.
Drawing, okay, stop. Then call for the trial court record, scan copy of the trial court record. List the matter after
2 weeks. Yeah.
2 weeks. Okay.
Lordship, in the meantime, Lordship, since the matter is pending before the London trial court.
We can stay,
Lordship, since your lordship has already,
but we do not know, but
because
whether, what is the stage of the trial?
Evidence, not even a single evidence has been taken place, Lord.
No, no, what, okay, but the
Evidence-
charge has been already framed.
Yes, charge is already.
Okay, then
because
let a complainant.
I'm already making a dispute with regard to such settlements not being considered by this court.
So, in that case, it is better to proceed with, because if there is no evidence, if the informant doesn't have any grievance against the petitioner or doesn't give any evidence, I think automatically the case will go in your favor only. Will not stay at the moment. It's a case of that. Okay.
Item number 5.
None appears. I think none appears on behalf of the appellant on call. Yes.
My senior advocate want to attend in the video conference, but when they filed the prenup at the time, wrongly recorded the phone number. That's why unable to attend. to the, if possible, the Lordship kindly pass this matter.
This was filed in the month of July.
Lordship.
He did not appear. And then second time also he did not appear. I was about to dismiss. Mr.
B poem, sir. Lordship. I
Learning
understand.
Council submitted his senior, who as does,
Yes, that's Lordship.
was to appear in the case by way of through video conference. However, due to what is number wrongly given.
Yeah, Lordship.
Okay. The recording of the wrong phone number in the registry. He could not be connected in the video conference. Therefore, pray for adjournment of the matter to be listed again after a week. Prayer allowed, list the matter after a week. Okay.
Item number 7.
My lordship, the council is in his like in court number 2. This matter may be passed by.
Pass over for the time being.
Yes.
Yeah. Okay. No.
Alright.
Time being.
Item number 8.
It's only time being, huh?
Your Lordship, item number 8, I've been just informed that the officer in charge, he has been in a law and order situation duty in that particular area where the dispute is taking place, Your Lordship, and therefore he could not prepare the CD, Your Lordship. He's on ground with regard to the taking care of the situation. If Your Lordship gave us some time to produce a CD, Your Lordship.
He was granted interim.
Yes, we did, Your Lordship.
In the same area he
Yeah, the situation I've been informed is still very intense, Your Lordship.
okay.
And there are people from both the states with barricades and everything, Your Lordship. And therefore, he's not being able to update his CD, Your Lordship.
Okay. Miss Tijini, learned additional PP for the states submits that due to the continuous law and order problem in the area, the IO could not prepare and send send the scanned copy of the case study is called for. Therefore, she prays for further time. The prayer is allowed. Stop. List a matter after 2 weeks.
Your Lordship, on 14th, Your Lordship.
On 14 list as prayed for list a matter again on 14 stuff. Mr. C. Tajulana counsel for the petitioner is also present. Okay.
Item number 9.
Your Lordship, I am appearing on behalf of the petitioner in item number 9. It is a restoration petition which was filed in September 2025, and we have already served the respondent 4 times, Your Lordship. Respondent number 2 has been served, and on the last date, time was given to serve respondent number 3 to through the concerned police station. So the service report was awaited, Your Lordship.
Respondent number 3, unserved notice return to the OCPS and Sam is kept it. Unserved.
Your
What is
Lordship, we have served on the address that we had used while filing the criminal petition, and we have also served her on the address which was mentioned on her passport, and this is the 4th time that we have served her. And this time it was through the concerned police
Just
station.
a minute, Learning Council, just a minute. Notice could not be executed due to, okay, late receipt of the notice. Due to late receipt, huh? They received lately, so that is why it could not be served on time. I requested to kindly issue fresh notice to informant with sufficient time for the service. So probably it's a little far away, maybe.
Yes, ma'am.
I think you have to take fresh steps in that case. We'll have to give a little longer time. Because here in Arunachal Pradesh, what happened is that even the police receive also, they have to walk long. And then if the notice is received lately, then it will be difficult for them to serve it.
Your Lordship, then
It cannot. But they have
Your Lordship, I
after
can
the
take
date is
fresh
over.
steps, but this may be the last opportunity
What
because
does
Your
it
Lordship.
what does it mean the late received? Could have served.
Could have served, yes, madam. Maybe
It was on 24th of
maybe
course.
because the date was fixed, my lord.
25.
That is why, my lord, I have earlier also
25.
submitted, because on last occasion also, my lord, the date was fixed today itself. So for that reason, perhaps, my lord, they are unable to serve it on or before today itself, my lord. That is
So
the
this was
reason
on-
they have sent it back, my lord, because it's a fixed, because the matter has been fixed, my lord.
So it was received by the police on 25th. 8. Could have served. Whether the person appear or not, different matter.
It was on 25th 8, my lord. The matter was taken up on 17th 8, and again it was fixed on 31 8, my lord. Because, my lord, they may have the impression that this matter is a fixed matter. So for that, my lord, they have
Will
to
not reach.
immediately
Hmm.
serve it within a time. Otherwise, my lord, as your lordship is aware, my lord, the police, when any order comes from the court, my lord, they become very, my lord,
Alert. Okay.
yes, alert, my lord.
Okay, yeah, then we'll fix another date. Notice has not gone to them, so it has to reach. Hard miss.
Yes, Your Lordship.
Land Council for.
Your Lordship
Yes,
may
okay.
provide a sufficient time, whatever Your
Yes,
Lordship
yes.
pleases.
Miss
But
is-
Your Lordship, my request is that this may be the last opportunity because this restoration
yes,
is
it will be
pending
last for
since
you. It
more
will
than
be
a
last
year,
for
Your
you.
Lordship.
It will be last for you. You have to call service. Of you have to call notice. Ishita Misra,
Yes, Your
Land
Lordship.
Council for the applicant. Also had Mr. T. at the Land Additional PP for the state. How many respondents are there?
2, my lord.
Okay.
One already
Your
complete.
Lordship.
Respond number 2
Okay.
already complete.
The office note dated 29/8. Okay, 31. So it's difficult to receive back also. It takes little time.
Yes, madam.
29/8/26. Reflect that the notice upon the respondent number 3 return unserved due to late receipt. Staff, in view of the above, Ms. Ishita, Land Council for the applicant. Praise for permitting her to take fresh steps upon the respondent number 3. Staff, prayer aloud. Staff, notice, press notice upon the respondent number 3 by a speed post. No,
my lord. Jurisdictional PS, madam.
Okay.
And my lord, may kindly direct
step
the
be taken
concern.
upon the respondent number 3 through jurisdictional police station. Okay. Jurisdictional police station.
They may
Within-
directed to, my lord, make all the endeavor to serve the notice, my lord.
Within 3 days, the police is directed to make endeavor to court service of notice upon the respondent and return on time. Stop, ma'am. Okay, yes, ma'am. Stop. Is requested. You want fixed date?
Yes, Your Lordship.
List the
Your
matter
Lordship,
again.
because
only-
I,
My lord, let it be after 2 weeks, my lord. One notice will come, my lord. Then again we'll fix the matter, my lord.
Your Lordship,
We'll
since
fix
I
it-
have
we'll fix it
to,
on, fix it on 17. Sorry, 16. 16. Okay.
Okay, man.
grateful, Your Lordship.
All right.
Item number 10,
Your Lordship, sorry for interrupting. Your Lordship, in item number 8, there is interim.
So what can we do?
It may be continued.
Okay. Continue. Item 8, the interim order pass earlier shall continue till the next date of listing, huh? Okay. This is item 10.
Lordship, the leading counsel is out of stations, so he could not able to attend. So this matter may be fixed after 3 weeks.
Just a minute. Mr.
M.
Learning Counsel for the appellant. Also had Mr. Jenny, additional PP for the state service. Upon the respondent number 2 is still awaited. In view of the above, please the matter after 2 weeks. Okay.
Operation.
item number 13 and 14,
My lordship, this matter may be also passed by for time being,
What?
because the council is in his like in court number 2. There is IA in this
Okay.
item number 13 and
13
14.
and 14.
Yes.
Counsel for the respondent is,
Sir, वहाँ पे,
who is for the applicant? You're present. Okay, counsel for the respondent is on leg.
yes, Your Honor.
13 and 14
Yes, maybe take it after after break.
after break.
Yeah.
No, we'll take up this one. It may not reach after break also.
Okay, for time being.
Okay. 13 and 14 timing.
item number 15,
My lord, on the last occasion, the private respondent has directed to file the reply on IA. Still, they have not filed, my lord.
No, that's fine. When? I is for what?
IA is for this lane compensation matter, my lord. Lane
Okay.
compensation. Government call.
Okay. You are appellant in the IA.
Because the
Government advocate also not yet filed any additional affidavit.
They sought from the instruction only.
Okay.
They have already received the instruction.
The instruction probably may have to be filed in affidavit form. You have to bring out it on record, I think. I think that will be better. That will be better. I think then you bring it on record. In that case.
In the order also is reflected, my lord. Reflecting the order also, in the main case, in the appeal.
Okay. Already paid.
Yes, already they have said that their amount is already dispersed.
Okay. Mr. Nega, you are in the for appellant.
Yes, ma'am.
Okay. And then this IA is filed for,
At least for filing for interim stay of the order. And the freezing, to freeze the account of the,
IA also filed by you.
yes, my lord.
Okay,
Is it,
then let them file in, bring it on record. Huh? Okay, and same, okay.
my lord, this is
Third, Mr.
urgency, my lord.
P. Nagar, Learned Counsel for the applicant staff, huh? Mr. N. Ratan, Learned Additional Advocate General for the state, submits that he has received an instruction and sought for some time to bring it on record by way of filing affidavit. The prayer is allowed. Stop. Mr. Menjo, Learned Counsel appearing on behalf of the respondent number 3 to 8. Also pray for further 2 weeks' time.
No, my lord, they are filing today.
You'll file today? Oh, sir.
It may not be listed, my lord, on 2 September.
Okay,
my lord.
submit, Major submits that they are filing objection today itself. Okay, stop. In view of the above, comma, list the matter on, we'll see some
Second-
14.
My lord, 2nd September, this,
Hmm?
2nd September, my lord. My lord,
2nd
is this
September.
urgency, my lord?
What urgency? Already released. What
Already released, but
Already released. It's not. Hmm. 14, okay.
my lord, there is an urgency, man, that's why, because
Already
if-
released. What
if-
is the urgency?
if all the amount had to release and they had withdrawn, then that's the problem, my lord.
That
Otherwise,
is
we
what
have to
he's
go to civil
submitting.
court.
Amount has been released. There's no question of not withdrawing.
We are,
Immediately after release,
we are taking only 70% of that amount, not whole amount.
Huh.
If the amount, some amount is being, in the bank, that
Huh.
has to be freeze, my lord. That's why.
You go through the affidavit filed by, objection filed by them also. You may probably have to file reply also.
No, my lord, it's okay.
Yes, sir.
But-
You have seen.
Yeah, well, we
have
not,
received.
did not require. We know because they are the caveat in this petition already.
Okay, caveat.
Caveat already. All
Okay.
the records are in the petition, my lord. So
Okay. Okay.
always.
Item number 16.
Yes.
Your Lordship, this matter will be referred for a medicine trial.
Hmm. Whether the respondent appeared earlier?
No.
Hmm?
No.
But the respondent need to appear. What happened? Not yet appeared, not even single. How many respondents are there? Hmm? Mr. Tajo, how many respondents are there?
So 3.
Earlier appeared. Then probably Wakalatnama withdrawn. Are you otherwise ready for mediation?
Yes.
Hmm?
Yes.
Okay. No, the respondent did not appear. No, Mr. Tajo, even if we send it for the mediation also, unless the opposite party or the respondent appeared, how it is not possible. First of all, respondent need to appear. Thereafter, only it can be sent for mediation.
Yes.
They are yet to appear. You have not taken proper, I think, steps. You were to ascertain the correct postal address of the respondent. Hmm? Have you taken steps thereafter? Oh, no, you have not yet taken steps. Hmm? What is this? 2016. It's a very old case. Who will dismiss? 2016 case. You could not serve the notice to the respondent till date. 10 years, I think, is sufficient. Even what is incomplete address? I think 10 years is sufficient time to ascertain the correct address of the respondent and to serve. You can walk on foot also. You can reach in 10 years. For the namesake, you get it listed and then what is the value? It's really 2016. 16 and I think this civil revision petition deserves to be dismissed. Yes. You tell the court what to do.
There was a last chance maybe.
Okay. I think there has been last chance. Second last, third last. Mr. Tajo, Planning Council for just a minute. Huh? The office note dated 29/8/2026 reflect that the petitioner has not yet taken steps for service of notice upon notice. No. Stop. Huh? It appears that the petitioner has not yet ascertained the correct postal address of the respondent. Stop. Huh? Mr. Tajo, and counsel for the petitioner submits that he may be granted further 1 week time as a last chance to take to ascertain the correct postal address of the respondent and to take steps. Stop. Huh? The prayer is allowed. The petitioner is granted last chance to ascertain the proper and correct address, proper address of the present address, present postal address of the respondent and to take steps thereafter by speed post as well as by usual process. Stop, huh? Dusty service is also allowed. Stop, huh? Para. And then it is also allowed, huh? Steps within. Then make it 2 weeks. Steps within 2 weeks. No. 1 week time is for ascertaining the correct address, and further 1 week time is for taking step, and a step be taken within in another 1 week, within another 1 week thereafter. Stop. Huh? List the matter after 5 weeks. Okay.
Bless.
Item number 17.
Yes. So it has been listed for referral to the mediation.
Yes, my lord.
Can we pass order for?
No, my lord, it is not possible, my lord.
Not possible. Why? Yeah. Irreconcilable. Oh. Is it? Yeah. Then why they have listed? Legality has been challenged. Of the appellate authority. Now, if the party agree, so the appellate that may not be required also if the party agree. What is this about? Maybe. Okay. But what was the dispute? See, if that is settled, the legality of those appellate authority, that will no longer survive. Mithun dispute. That is why probably the High Court also understood that this can be settled through mediation. Explore. How many Mithuns involved? Oh, I think legality may not be required. Mithun is no longer, I think, not Mithun gone. What remains there? I think it's always explore. Both one Mithun, cut it and eat it. See, it's only the fight of ego only. So it is always better someone say, for example, the involvement of the advocate, counsel. Here, the role of the advocate comes. At no point going ahead. A little bit of sacrifice, little bit of compromisation is to be done by both. Can we just explore it? It's always better. No need to spend. Huh? So tell them that because of your fighting, you are spending money on me, not on, and then it's enough for me. Tell them that it's enough, that much, that is enough for us. Huh? Okay. Hard, Mr. This is item 17. Okay, hard, Mr. Lawland, huh? No, you are for respondent only. Okay, Miss
M. Karbak.
M. Karbak, Land Council for the petitioner. Also had Mr. Kemmo, Law and Land Council, appearing on behalf of the respondent. Stop, huh? The matter is listed. This matter is listed for referral to the special mediation drive. Mediation for the nation, huh? This matter is listed today, huh? Okay. No, just a minute, huh? This matter is listed today for, because these all are, there are some matter, the order will be similar, that is why, huh? This matter is listed today for consideration of its referral to the special mediation drive, mediation for nation, under a special mediation drive, mediation for nation staff, para. Land council appearing for the parties submits that the dispute, although the challenge is with regards to the legal authority, otherwise challenge is for. Okay, challenging the jurisdiction of the appellate authority. However, they submit that however, the dispute, the core dispute was regarding the Mitun.
Yes, my lord.
Okay, and therefore they submit that there is an element of settlement, and the dispute may be explored through mediation staff on para. Considering the nature of the dispute and possibility of amicable settlement, this court is of the view that the matter deserve to be referred to the mediation center staff. A mediation staff to the mediation staff. Accordingly, the present civil revision petition is referred to the mediation center for settlement staff. The registry is directed to place, transmit all the relevant records of the case before the mediation center for the purpose of conducting mediation proceedings. Staff, para. Both the parties shall appear before the mediator on the date and time fixed by the mediation center staff. Para. The mediator shall submit report of mediation proceedings to the court upon conclusion of the mediation staff. The mediation thereafter, staff. Para. Least after receipt of the report of mediation, report of mediator. Okay, mediation, Okay.
Obliged.
Item number 7, passover matter.
Item 7. Okay.
Yeah. Second bail application, initially, bail application was filed by but this honorable court directed the petitioner to approach the trial court first. So thereafter, the petitioner moved the bail application before the trial court, but that was rejected. Therefore, this is the second. On merit, this is otherwise the first bail application of the extension. FIR, FIR, it was filed on 1/4.
No, this is bail application. No, accusing. What is the? Okay, FIR is it?
My lord will find FIR at page number 15. My lord, case is at the trial stage, my lord.
Trial stage.
Trial stage, my lord. As of today, my lord, 34 witnesses have been examined, my lord. And out of, I think, 45 or 46, together witness. My lord, I was arrested, my lord will find. So far, my lord, I'm not on merit. This allegation, all those things, but basically against me is the case like on circumstantial evidence.
Okay, just a minute, sir. Just a minute. The FIR is got a telephonic call. Okay, this case.
Yes, my lord.
Telephonic call from the association online is got. Oh no, I had not. So the colony with spotted immediately on getting the speak here. Okay, this is the fire. Charge sheet or filed against how many accused?
3 accused, my lord. And
3 accused.
all of them.
Where is the operative portion of the charge sheet? Can we just see once?
Charge, my lord, starts from page number 21 onwards, my lord.
Okay.
And my lord will find findings, page number 39
Okay.
below, my lord. Today, my lord, on merit, I will not argue, my lord, about this in materials, all those things, my lord.
Okay, then what?
My
Then on.
argument will confine, my lord, that Article 21 violation, my lord. Because
Okay. But the trial is going on, you said?
my lord,
Trial.
trial is going on.
The
But the
evidence, how many evidence recorded?
34, 35.
34. It is continuing only?
Continue.
How many total? How many witnesses?
47, sir.
47. Out of that, 34 already
That
recorded.
is there, no doubt.
So around 13 remains.
Yes. Basically, this is the case, my lord. There is no such direct evidence. But of course, in that
Just a
case,
minute. Where do we find his name in the charge sheet?
my lord will find it. That's why I'm saying, my lord, kindly turn to page number 39.
Yes, 40. Okay, 39. Yes.
39, accused number.
What is his name?
Asif Hussain.
Asif Hussain.
Yes, ma'am.
Okay. Saddam, Asif, and Ramzan.
My lord, before coming to the my lord submission, my lord,
Mhm.
in nutshell, my lord, I will just apprise this one over the facts, my lord, reading under what circumstances I was arrested, and what is the allegation, my lord, basically.
Mhm.
Basically, my lord, this what FIR was lodged on 1/4/2022,
Mhm.
saying, my lord, that a person was found dead who was a sub-inspector, police, in his room,
Mhm.
found with full of blood, my lord.
Mhm.
And thereafter, my lord, the investigation was carried out. FIR is against unknown person. Investigation was carried out. And during the investigation, the police came to know that one of the Saddam Hussein,
Mhm.
he was working with the victim. They were like, he was working as an agent for the victim because the victim used to lend money in interest in the market, So this Saddam Hussein, one of the accused person, he used to work as an agent. He used to collect the money for the victim and he used to collect money in interest and he used to pay back. So in the process, in even Saddam Hussein, I think he, without informing the victim, he might have misappropriated so much amount also. So thereafter, this Saddam Hussein, the accused number one main accused, what he did is, he come with some plan that since so many liabilities was there, so he wanted that to murder this particular victim because he wanted to take all the money which was lent by the victim. So it is the prosecution case. In that situation, this Asif Hussain, who is I have enclosed even the birth certificate, is a juvenile at that point of time. So along with one more Ramzan Alam, this Saddam Hussein, he mastermind all the thing. And it is the prosecution case that along with these two accused person, my lord, they went to the house of the victim And they made some, they arranged for some party. And after that, brutally, these 3 persons jointly murdered the victim. Basically, investigation in that. So I was arrested on 6/4/2020. Since then, till now, I'm in the custody. So thereby, my lord, it's 4 years, almost going to be, I think, 8 months, something like that, going to be 5 years, maybe, my lord.
Okay.
So continues, I have been in the custody. So far, entire charge sheet also, this is not no direct evidence, but circumstantial evidence. I am not going deeper into those questions. That will be the matter of.
They've given 164 statement also.
Maybe those things are there, saying
It's
that
there.
these are the circumstances, all those things. Of course, that will be taken care during the final hearing. Basically, my lord, I am before this lordship. Is that, my lord, that this period, my lord, almost going to be 5 years. We cannot take it so easily also, my lord, for that. Because law says, my lord, of course, deprivation can be done through the law. Article 21 says that no one shall be deprived of life and liberty except in accordance with the due process of. Now, procedure of law, it doesn't mean that any procedure is laid down. So that has become no procedure. Manika Gandhi case has all long time been, it has been settled. Procedure means fair, reasonable. That is procedure. It is not something that any law is prescribed that become automatically fair or reasonable, not. Then this facet has been discussed in so many cases when the matter came up, especially my lord saying that speedy trial is one of the facets of Article 21. Of course, to the both the parties. Now, accused person as on today, whatever may be the allegation, my lord, law presumes him to be an innocent, my lord, as on today. This is the Article 21. Says that deprivation is permissible, but in terms of the due process of law, and the procedure of the law should be fair. Now, I am before this honorable court saying that is it fair procedure? Keeping a person for more than 5 years, this has become a punity rather than a kind of a preventive, my lord. That's the basic purpose of the person keeping detention, basically at the time of hampering, tempering, all those parts, plus a person may jump, all those grounds are. Now, nothing is there. Now, questions before my lord is keeping a person without releasing bail, and the state is not in position to complete the trial within a reasonable period, my lord. Now, it's almost going to be 5 years. It will go, my lord. After prosecution, my lord, so many, even now, official witness, 313, defense witness, will definitely hearing, argument, judgment, my lord knows. Now, on this aspect only, my lord, and moreover, I have even my lord, enclosed my birth certificate also. I was a juvenile at that point of time, my lord.
Have you raised this before the trial court?
Yes, my lord, because last time when I appeared before this honorable court, this honorable court directed to raise this issue, raise the issue. That has been declined by the learned trial court, my lord.
Okay.
Now,
so that means he was not a juvenile at the time of.
my lord, that part I have taken a plea. That part, whether I was juvenile, that I will take in a different proceeding. For there is a.
No, you said it was
I
rejected.
have raised in my bail.
Has it been rejected? No.
Rejected, my lord.
Okay.
In bail, rejected.
No, in bail.
Bail.
Well, you have not raised this question.
Separately, I have
Separately,
not, but in the bail application, I have raised that question.
Okay, no.
But that has been rejected. Now, these two aspects, my lord. Now, my lord, law as we know, my lord, as says, my lord, that Article 21, that the series of judgment is saying is that, my lord, that when a person is kept behind prolonged trial, during the trial, and the state is not in position to provide a speedy trial, then it is not right on the part of the state to object the bail.
See, the recording of 33 prosecution witnesses is not a joke.
I understand.
So is there any instances where you think that the state there is a laches on the part of the state on the prosecution side?
4 years, 5 years, my lord.
Maybe, but because because the witnesses are more here in this
That's
case.
why, my lord. That's why, my lord, whatever may be the circumstance. The law says that, my lord, if we want to be saying that this procedure has to be fair, we cannot go and find out that what is the, but only the thing that it should not happen out of my conduct. But this is not the case. The delay is not because of my conduct. I have been in cases.
I think the dates are continuously given.
Given my lord knows that docket is full of cases, and of course trial court has been also doing its best.
But what can,
But
unless there is a laches, unless there is a, the prosecution is.
my lord, that this is not the question where to show the lurches on the part of the state. Only the question is that it has to be concluded within a reasonable. And if you have faith, whatever may be the story, you cannot justify it, saying that these are the reasons so that we can keep on the continuation, because that will infringe Article 21. This is basically, and most of the cases in Vienna, our Honorable High Court decisions are there, my lord. 2 years, 3 years, that this is undue delay. But my case is fine. My lord knows that Lisironi case, where the wife was murdered brutally by hiring the people. So he was put in the jail. So there the matter went to the Supreme Court. Apex Court said that no, this has affected Article 21. This is undue delay. It was in the 4 years, something like that, in the jail. So immediately he was released, madam. I have that judgment. Only on that fashion only, that fact only, madam. So, my lord, I implore this honorable court to consider this particular plea, where in this particular case, whether my right, this Article 21 has been infringed. Only that aspect, madam. So, with this, my lord, I would like to place some judgment on this regard, my lord, that how this our judicial opinion so far this Article 21 is concerned, my lord, that with taking, my lord, going in the direction that 4 and 5 years is not a matter to be taken so lightly, my lord. Rather, it has become a punitive imprisonment. It has not become a, my lord, purpose is not served, my lord. Now, my lord, that part is there, my lord. Then it has become a punitive, my lord. Then length of custody, my lord. Then unlikely this trial will not completely, will not be completed, my lord. Then, my lord, will see even DNA report is yet to be filed in the court, my lord. So, considering all these things, my lord, that right to liberty, Article 21, now at this stage, it outweighs the need for continued detention when, my lord, almost all the, definitely those question of tempering, hampering will not come at this stage at all. So, this is basically my case, my lord. I'd like to rely on some judgment, my lord. Long time back, Hussain Ara Khatun 1980 itself, my lord. This has been relied in Javed Ghulam judgment. I will start with Javed Ghulam judgment. Para 9, my lord. Javed Ghulam Nadi Sheikh case, my lord, it is under more stringent statutory act, my lord. This is under the Unlawful Activities Prevention Act 95, where there is a bar to grant the bail, my lord. But our case is not something, my lord, there is a statutory bar, my lord. Unlawful Activities Prevention Act 1977, there is an absolute bar, my lord, that when bail cannot be given, my lord, when it should not be given, there is a bar. Even NDPS case, my lord, there is a bar. But the series of judgment, it demonstrates, my lord, that when constitutional right, fundamental right is involved, my lord, that statutory bar will not take over the fundamental rights, my lord. And in that time, my lord, the Honorable Court is not prevented from enlarging the accused person on bail whenever this fundamental right is infringed, my lord. My lord, I will start with para 9, my lord. All these important judgments has been discussed in this particular judgment about the speedy and right of the accused person, my lord. I'll just read it out, paragraph 9 onwards, my lord. The same principle has been reiterated by this court in Gurbakh Singh so and so, that the object of bail is to secure attendance of the accused at the trial, that the proper test to be applied in the solution of the question whether bail should be granted or is whether it is probable that the party will appear to take his trial, and that is indisputable that the bail is not to be withheld as punishment. Now 10, paragraph 10, my lord. It started with this Husainera Khatun judgment, my lord, 1980. It's decided in 1980, my lord. We're in 2026. Long back in Husainera Khatun versus State of Bihar, this court had declared that right to speedy trial of the offenders facing criminal charges is implicit in the broad sweep and content of Article 21 as interpreted by this court, remarking that a valid procedure under Article 21 is one which contains a procedure that is reasonable, fair, and just. It was held so and so. Now, obviously, procedure prescribed by law for depriving a person of liberty cannot be reasonable, fair, and just unless that procedure ensure a speedy trial for determination of the guilt of such person. No procedure which does not ensure a reasonably quick trial can be regarded as reasonable, fair, or just. And it would fall of Article 21. There can therefore be no doubt that a speedy trial, and by speedy trial we mean reasonably expeditious trial, is an integral and essential part of the fundamental right to life and liberty enshrined in Article 21. The question which would, however, arise as to whether what would be the consequence if an person accused of an offense is denied speedy trial and sought to be deprived of his liberty by imprisonment as a result of long delayed trial in violation of these fundamental rights under Article 21. Thereafter, my lord, para 31. Again, those judgments have been, my lord, taken into consideration. Then 12, then 15.
Para?
My lord, from 9, 10, 11, 12. These are the some other judgments they were referred, my lord. Then I will come to, my lord, paragraph 15, my lord. Paragraph also, my lord, Satyendra Kumar until versus CBI, that has been discussed, my lord. Now, conclusion, my lord, para 16, my lord. 16, 17, I will read para 16. Criminals are not born, but made. The human potential in everyone is good, and so never write of any criminal as beyond redemption. This humanist fundamental is often missed when dealing with delinquents, juvenile and adult. Indeed, every saint has a past and every sinner a future. When a crime is committed, a variety of factors are responsible for making the offender commit the crime. Those factors may be social and economic, may be the result of value erosion or parental neglect, may be because of the stress of circumstances or the manifestation of temptation in milieu of affluence contrasted with the indigence or other privation. Para 17, my lord, this is very important. If the state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial, as enshrined under Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that the crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of crime. 18, my lord. We may hasten to add that the petitioner is still an accused, not a convict. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly, however stringent the penal law may be. Para 19, we are convinced that the manner in which the prosecution agency as well as the court have proceeded, the right of the accused to have a speedy trial could be said to have been infringed, thereby violating Article 21 of the Constitution, so and so and so. My lord, in this case, I think under unlawful acts, my lord, the accused was maybe for how many? So it was, my lord, reaffirmed that, my lord, as said that considering all this series of judgment regarding speedy trial, the question is, my lord, whatsoever may be the reason, that cannot justify prolonging the trial. It is the it is incumbent, my lord.
We'll take a break for 4 minutes. Okay.
My lord, in this
Yeah.
case particularly, which I have just covered, was kept only for 4 years. My case to matter, that most is going to be 5 years. In that case, matter, unlawful activities is more extreme than IPC. IPC, although it is a heinous crime, I'm not saying that. But as on today, matter, still law presume it to be heinous. So, keeping this facet, matter, there is a judgment is saying, matter, no. Now, state cannot come with the plea that for this reason, that reason. Only the thing is that this keeping a person for almost going to be 5 years and unlikely to be concluded soon. Can we say, my lord, that this is reasonable, this is fair? No amount of justification can satisfy.
Just a minute. What was the ground taken before the trial court? This ground taken or some other ground?
This grounds, my lord.
This ground. On this ground rejected.
Yes, this ground as well as
saying what?
Juvenile also, my lord.
What was the ground for rejection?
Rejection, my lord, saying that basically saying I am from outside of the state, likely to abscond, my lord. How under right after keeping me 5 years? Does it mean, my lord, tomorrow suppose 8, 10 years, this matter is pending, my lord, because only from I was out of state, but this is not, my lord, legally, my lord, tenable, my lord. Now, I am
legally you're right.
My lord.
Legally you are entitled.
My lord, only not saying because maybe, my lord, the allegation is not saying I am saying it's a good allegation. This is very serious. But there is, of course, our constitution balances the thing also, my lord. We are governed by the rule of law, my lord. Whatsoever with the allegation, because we cannot just come to the conclusion only because some allegation is there. Now, 5 years almost, it's not a job also, my lord, and that too without any determination. Now, question comes, my lord, since the constitution itself provides me that right, because deprivation is under Article 21, procedure has to be reasonable. Now, my lord, this protracted trial cannot be said under any circumstances. This is a reasonable, fair procedure. This is basically, my lord, what this all judgment has been saying, my lord, cannot be, my lord. So, my lord, with this, my lord, one more, our own High Court judgment, this particular judgments have been taken care into also in this case. This is a murder case. This is NDPS case. This is more serious NDPS case, all those things, my lord. There is a bar.
Yes.
My lord, may I take with the para 10? Para 10, my lord, that Hussain Khatun judgment that has been referred, my lord. Then 11, my lord, Abdul Rahman Antule case, my lord. Then para 12, my lord, this particular judgment of Supreme Court Javed Ghulam Nabi, my lord, that has been referred in para 12, my lord. This aspect has been taken into consideration. Thereafter, my lord, para 14, my lord, court on findings, my lord, para 14, my lord. I'll read para 14 and 15. May I read, my lord? From the above decisions so rendered by the Supreme Court, it is therefore clear that the right to speedy and expeditious trial is not only a vital safeguard to prevent undue and oppressive incarceration, but it is also to mitigate anxiety and concern accompanying the accusation, as well as to curtail any impairment in the ability of the accused to defend himself. Well, look, another one ground is also there, my lord. If I kept in that way, my lord. Now, how will it's expected that I will be able to defend my case properly also, my lord? Then itself it is not the, my lord, fair procedure, reasonable procedure under Article 21. A person needs to have, my lord, that freedom to defend himself also, my lord. Freely, my lord. Keeping a person detaining inside the jail for a long time, and I think that person would be in a position to defend his case effectively and properly. There is also an overarching societal interest paving way for speedy trial. The concept of the speedy trial is amalgamated into Article 21 as an essential part of the fundamental right to life and liberty granted and preserved under our Constitution. The right to speedy trial begins with the actual restraint imposed at the time of arrest of the accused and the consequent incarceration, which continues at all stages, namely stages of investigation, inquiry, trial, appeal, and revision, so that any possible prejudice that may result due to impermissible and avoidable delay since the time of the commission of the offense till the criminal proceeding consummates into a finality could be averted. The speedy trial, early hearing, and quick disposal are sine qua non of criminal jurisprudence. The overcrowded court dockets, the heavy volume of work, and the resultant pressure on the prosecution and the police individually keeps the entire criminal jurisprudential mechanism under stress and strain. However, Your Honor, this cannot be an excuse to keep the accused in incarceration for an indefinite period of time. It does not serve any credit to the criminal justice system. Rather, it makes for a safe state of affairs. Para 15 mal. The guarantee of a speedy trial is intended to avoid oppression and prevent delay by imposing on the court and the prosecution an obligation to proceed with the trial with a reasonable dispatch. The guarantee serves a threefold purposes. First, it protects the accused against oppressive pre-trial imprisonment. Secondly, it relieves the accused of the anxiety and public suspicion due to unresolved criminal charge. And lastly, it protects accused the risks that evidence will be lost on memories dimmed by the passage of time, thus impairing the ability of the accused to defend himself. It goes without saying that the consequences of pre-trial detention are grave. It is a settled position as per criminal jurisprudence, then accused is presumed innocent till proven otherwise. This court cannot be unmindful that the burden of detention of such an accused frequently falls heavy on the innocent members of the family. My lord's particular query about this, maybe there may be reason, so many other reasons, without any delay or latches also. This aspect has been given, this cannot be the justification at all, my lord, because that cannot curtail fundamental right, my lord, which is that because once state is saying that I am infringing your right, I am putting detention, my lord, there cannot be, my lord. This is the highest right, is right to life, my lord. And with this, my lord, one more, this Visironi judgment, my lord. Just not deal with aspect only in this aspect, my lord. This crime was very infamous in our state, my lord. Para 4 and 5.
Yes.
Para 4 and 5. This case is infamous for its, my lord, peculiarity where a husband having illicit, my lord, it is in the public domain itself, my lord. Then bail was rejected by our court, my lord. Then matter went to the Honorable Apex Court and said that para 4. The petitioner was arrested on 10/11/2020, my lord, and is suffering incarceration since then, my lord. His order is 23/9/2025, 10/20. Then, my lord, it was almost 5 years, my lord. In view of the facts and circumstances, keeping in view the personal liberty of the PD, we consider it to be enlarged. Nothing discussed, my lord. Only that for 5 years, my lord, whatsoever may be the, my lord, allegation. This is not at all, my lord. With balance has to, otherwise, my lord, this Article 21 fundamental rights will not have any value at all.
Let us say an order passed by the Supreme Court.
No, my lord, because everybody doesn't have that, my lord. My lord is Supreme Court only.
Only Supreme Court can pass this order.
No, my lord has also power. Article 21, my lord is the protector of fundamental. Entire court has that power, my lord. Only my lord has to see whether I have a right or not. If my lord thinks that no, I don't have a right, of course, my lord, I will not insist for it, my lord. But I am here before my lord is that I have a right under Article 21 that has been infringed in particular case. And when such violation is brought on record before this honorable court, my lord, then I pray, my lord, my right may be protected, my lord, at least, my lord, because nothing will happen, my lord, I will defend my case. My lord. With this, that is only my case.
Yes.
May it please your lordship.
Yes.
My lord, without taking much time, my lord, there are 3 accused in this case. And one of the accused case has been recently rejected by the coordinate bench, my lord. All this aspect has been taken into consideration, my lord. The delay in trial, whether the trial is progressing or not, my lord. The coordinate bench on 5/8/2026, my lord. This is the Ramjan Ali, one of the co-accused.
Because he has clarified in
Yes,
the
madam.
very beginning that he's not on merit. of the case. Merit on merit, of course, there is a
Yes, my lord.
material against.
On that aspect also, my lord, delay in trial also, that has been also been considered by the my lord coordinate bench.
Mhm.
It was rejected in 5/8/2026.
Mm.
My lord will find in the operating paras are 7, 8, 12, 13 and 15, my lord. There also, my lord, they discuss how many witness has been examined, my lord. Even the learned coordinate bench has directed the learned trial court to, my lord, expedite the trial. So, my lord, that aspect has been
Has
considered.
to be expedited because the priority
Yes, my lord.
is to be taken.
Yes, Article my lord 21 is there. That is, no one is disputing, my lord.
Mhm.
But every case has to be decided by its own fact and circumstances.
Right.
And my lord, the progressing in the trial as well, my lord. Because, my lord, in this kind of offenses, my lord, 302, the societal interest will prevail over individual interest, my lord. And it has to be balanced, my lord. Because long incarceration, because of the long incarceration, one right under Article 21, my lord, it directly hit Article 21, but at the same time, my lord, when it intersects with the, my lord, a societal interest, that has to be weighed and court has to give due consideration of the societal interest as well, my lord. 302. So, my lord, on 302, my lord, I will rely some judgment, my lord, because, my lord, my lord is well aware of the Sanjay Chandra's case, my lord. That case was referred in the many judgments, my lord, where in that case, my lord, it has been held that, my lord, that the refusal of bail to an unconvicted person is amounting to give him a test of, my lord, imprisonment as a lesson. That is the ratio in the Sanjay Chandra case, my lord. So that was, my lord, referred in one of the judgment before the Supreme Court, wherein, my lord, the Supreme Court dealing with the 302 matter has distinguished that judgment, my lord. I will just read out the judgment, my lord. My lord, because that ratio was accepted to be the correct law, but that will applicable only in those cases in a general law, not in the offenses like murder, my lord. This is the case. It's reported in 2017-5 SCC 406, my lord. Biru Paksappa Godwa and another versus State of Karnataka. My lord, may kindly come to para 13 onward, my lord. Para 13, man. The proposition expounded above has to be accepted, but that has to be applied oppositely to the facts of each case. A bail application cannot be allowed solely or exclusively on the ground that the fundamental principle of criminal jurisprudence is that the accused is presumed to be innocent till he is found guilty by the competent court. The learned trial court judge has also referred to the decision in Sanjay Chandra, wherein a two-judge bench while dealing with the bail application observed thus. In bail application, generally, it has been laid down from the earliest time that the object of the bail is to secure the appearance of the accused person for his trial by reasonable amount of bail. The object of the bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it is required to ensure that the accused person will stand his trial when called upon. The court owe more than verbal respect to the principle that punishment begin after conviction and the every man is deemed to be innocent until duly tried and duly found guilty. From the earliest time, it was appreciated that detention in custody pending completion of trial could be a cause of great hardship. From time to time, necessity demand that some unconvicted person should be held in custody pending trial to secure their attendance at the trial. But in such cases, necessity is the operative test. In this country, it would be quite contrary to the concept of personal liberty enshrined in the Constitution that any person should be punished in respect of any matter upon which he has not been convicted, or that in any circumstances he should be deprived of his liberty upon only the belief that he will tamper with the witness if left at liberty, save in the most extraordinary circumstances. Apart from the question of prevention being the object of refusal of bail, one must not lose sight of the fact that any imprisonment before conviction has a substantial punitive content, and it would be improper for any court to refuse as a mark of disapproval of former conduct, whether the accused has been convicted for it or not, or to refuse bail to an unconvicted person for the purpose of giving him a test of imprisonment as a lesson. Now, my lord, the Supreme Court has given clarification to that. Be it noted, though the aforesaid passages from Sanjay Chandra case have their relevance, but the same cannot be made applicable in each and every case for grant of bail. In the said case, the applicant accused was facing trial for offence punishable under section 120B, 420, 468, 471, and 109 of IPC, and section 13(2), my lord, the economic offence, read with section 13(1)D of the Prevention of Corruption Act 1988. Thus, the factual matrix has quite difference. That apart, it depends upon the nature of the crime and the manner in which it is committed. A bail application is not to be entertained on the basis of certain observation made in a different context. There has to be application of mind and appreciation of the factual score and understanding of the pronouncement and in the field. Para 15. The court has to be keep in mind what has been stated in Chaman Lal versus State of UP. The requisite factor are, these are the general principle which has to be taken into consideration. The nature of acquisition, the severity of punishment in case of conviction, and the nature of supporting evidence, reasonable apprehension of tampering with the witness or apprehension of threat to the complainant, and prima facie satisfaction to the court in support on charge. In Prashant Kumar Sarkar versus Ashish Chatterjee, it has been opined that while exercising the power for grant of bail, the court has to keep in mind certain circumstances and factors. We may usefully reproduce the said pages. 9. Among other circumstances, the factors which are to be borne in mind while considering an application for bail are: 1. Whether there is any prima facie or reasonable ground to believe that the accused has committed the offence. 2. Nature and gravity of the acquisition. 3. Severity of the punishment in event of conviction. 4. Danger of the accused absconding or fleeing if released on bail. 5. Character, behavior, means, position, and standing of the accused. 6. Likelihood of offence being repeated. 7. Reasonable apprehension of the witness being influenced. And 8. Danger, of course, of justice being thwarted by grant of bail. 16. In CBI versus B. Vijay Sai Reddy, the court has reiterated the principle by observing thus: while granting bail, the court has to keep in mind the nature of acquisition, the nature of evidence in support thereof, the severity of the punishment which conviction will entail, the character of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witnesses being tampered with, the larger interest of the public state, and other similar consideration. It has also been kept in mind that for the purpose of granting bail, the legislature used the word reasonable ground for believing instead of the evidence, which means the court dealing with the grant of bail can only satisfy itself as to whether there is a genuine case against the accused and that the prosecution will be able to produce prima facie evidence in support of the charge. It is not expected at this stage to have the evidence establishing the guilt of the accused beyond reasonable doubt. From the aforesaid principle, it is quite clear that an order of bail cannot be granted in an arbitrary or fanciful manner. In this context, we may with profit reproduce a passage from Niru Yadav versus State of UP, wherein the court setting aside an order granting bail observed 16. The issue that is presented before us is whether this court can annul the order passed by the High Court and curtail the liberty of second respondent. We are not oblivious of the fact that the liberty is a priceless treasure of a human being. It is a founded on the bedrock of the constitutional right and accentuated further on human right principle. It is basically a natural right. In fact, some regard it as to the grammar of life. No one would like to lose his liberty or barter it for all the wealth of the world. People from centuries have fought for liberty, for absence of liberty causes senses of emptiness. The sanctity of the liberty is fulcrum of any civilized society. It is a cardinal value on which the civilization rests. It cannot be allowed to be paralyzed and immobilized. Deprivation of liberty of a person has enormous impact on his mind as well as body. A democratic body, polity, which is wedded to the rule of law, anxiously guard liberty. But a pregnant and a significant one, the liberty of an individual is not absolute. The society, by its collective wisdom, through process of law, can withdraw the liberty that it has sanctioned to an individual when an individual becomes a danger to the collective and to the societal order. Assent on individual liberty cannot be pyramided to the extent which would bring chaos and anarchy to a society. A society expects responsibility and accountability from its member and is desired that the citizen should obey the law, respecting it as a cherished social norm. No individual can make an attempt to create a concavity in its stream of social stream, it is impermissible. Therefore, when an individual behave in a disharmonious manner, ushering in disorderly thing which the society disapprove, the legal consequences are bound to follow. At that stage, the court has a duty. It cannot abandon its sacrosanct obligation and pass an order as its own whim or caprice. It has to be guided by the established parameter of law. Here also, my lord, the societal interest has been stretched by the Honorable Apex Court, my lord. Although Article 21 is there, my lord, we are not disputing that. Now, my lord, on long incarceration, my lord, which was held in, my lord, the Rajesh Ranjan Yadav, my lord, reported in 2007, 1 SCC 70, my lord. Para 10 to 12, my lord. Para 10 onwards. In our opinion, none of the aforesaid decision can be said to have laid down any absolute and unconditional rule about when bail should be granted by court and when it should not. It all depends on the facts and circumstances of each case, and it cannot be said that there is any absolute rule that because of a long period of imprisonment has expired, bail must necessarily be granted. As observed by this court in State of UP versus Amarvati Tripathi, para 18, it is well settled that the matter to be considered in an application for bail are whether there is a prima facie case reasonable. My lord, I will not repeat it. My lord, it is the same thing. Now, my lord, in the fourth last paragraph, while a vague allegation that the accused may tamper with the evidence or witness may not be a ground to refuse bail, if the accused is of such character that his mere presence at large would intimidate the witnesses, or if there is a material to show that he will use his liberty to subvert justice or tamper with the evidence, then bail will be refused. We may also refer to the following principle relating to the refusal of ground or refusal of bail stated in Kalyan Chandra Sarkar versus Rajesh Ranjan 11. The law in regard to the grant or refusal of bail is very well settled. The court granting bail should exercise its discretion to a judicious manner and not as a matter of course. Though at the stage of granting bail, a detailed examination of evidence and elaborate documentation of the merit of the case need not be undertaken. There is a need to indicate in such order reason for prima facie concluding why bail was being granted, particularly where the accused is charged of having committed a serious offense. Any order devoid of such reason would suffer from non-application of mind. It is also necessary for the court granting bail to consider, among other circumstances, the following factor also before granting bail. They are the nature of the acquisition, severity of the punishment in case of conviction, and the nature of supporting evidence. B, reasonable apprehension of tampering with the witness or apprehension of threat to the complainant. C, prima facie satisfaction of the court in support of the charge. 19. This court also in specific term held that the condition laid down under section 437(1) subclause 1, my lord, here 437 is sine qua non for granting bail even under section 349. My lord, meaning thereby there must be reasonable ground to believe that the accused is not guilty of the offense. That's what 437(1) subclause Roman 1, my lord, says. In the impugn order, it is noticed that the High Court has given the period of incarceration already undergone by the accused and the unlikely of trial concluding in the near future as ground sufficient to enlarge the accused on bail, in spite of the fact that the accused is then charged of an offense punishable with life imprisonment or even death penalty. In such cases, in our opinion, the mere fact that the accused has undergone certain period of incarceration, 3 years in this case, by itself would not entitle the accused to be enlarged on bail, nor the fact that the trial is not likely to be concluded in near future, either by itself or coupled with the period of incarceration, would be sufficient for enlarging the appellant on bail when the gravity of the offense alleged is severe and there are allegations of tampering with the witness by accused during the period he was on bail. Now, last, my lord, paragraph 12. The above decision has referred to the decision of this court in appellant's own case, Kalyan Chandra Sarkar versus Rajesh Ranjan, in which it was clearly held that mere fact that the accused has undergone a long period of incarceration by itself would not entitle him to be enlarged on bail. Two more, my lord.
Two more. I think that is enough.
My lord, recent also I will give, my lord. The recently, my lord, held by Supreme Court. This is the old one, my lord. This is the full bench judgment, my lord.
Petitioner has given only 3. Okay.
Para 19 and 20, my lord, switch from and we'll start from para 18, my lord. This is 2005 to SCC 42, Kalyan Chandra Sarkar, my lord. Para 18, 19, and 20, my lord.
Okay.
It is straight law that personal liberty cannot be
We are
taken.
reading 17, 18.
18, my lord.
Okay, okay. Yes.
It is strict law that personal liberty cannot be taken away except in accordance with the procedure established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guaranteed the above right, also contemplated deprivation of personal liberty by procedure established by law. Under the criminal law of this country, a person accused of offense which are non-bailable is liable to be detained in custody during the pendency of trial unless he is enlarged on bail in accordance with law. Such detention cannot be questioned as being violative of Article 21, since the same is authorized by law. But even person accused of non-bailable offense are entitled to bail if the court concerned come to conclusion that the prosecution has failed to establish a prima facie case against him, and or if the court is satisfied for the reason to be recorded that in spite of the existence of prima facie case, there is a need to release such person on bail where fact situation require it to do so. In that process, a person whose application for enlargement of bail is once rejected is not precluded from filing a subsequent application for grant of bail if there is a change in the fact situation. In such case, if the circumstances then prevail, require that such person be released on bail in spite of his earlier application being rejected, the court can do so. 19. The principle of res judicata and such analogous principle, although are not applicable to a criminal proceeding, still the court are bound by the doctrine of judicial discipline, having regard to the hierarchical system prevailing in our country. The finding of the higher court or the coordinate bench must receive serious consideration. My lord, there is a finding of the coordinate bench at the hand of this court entertaining a bail application at a later stage when the same has been rejected earlier. In such an event, the court must give due weightage to the ground which weighed with the former or the higher court in rejecting the bail application. Ordinarily, the issue which has been canvassed earlier would not be permitted to be re-agitated on the same ground, as the same would lead to the speculation and uncertainty in administration of justice and may lead to forum hunting. Para 20. The decision given by the superior forum undoubtedly are binding on the subordinate for on the same issue, even in a bail matter, unless of course there is a material change in the fact situation calling for different view being taken. Therefore, even though there is a room for filing subsequent bail application in the case where earlier application has been rejected, the same can be done if there is a change in fact situation or in law which require the earlier view be interfered with or where the earlier finding has become obsolete. This is the limited area in which an accused who has been denied bail earlier can move a subsequent bail. Therefore, we are not in agreement with the argument of the learned counsel for the accused that in view of the guarantee conferred on a person under Article 21 of the Constitution, it is open to every person to make successive bail application even on the ground already rejected by the earlier court, including the apex court of the country. This on same issue, my lord, it cannot be re-agitated, my lord. This is the question that expect. My lord, the recently, my lord, the Supreme Court held by the Supreme Court, my lord, that prolonged incarceration and my lord likely to delay in trial itself cannot be a ground for granting bail, my lord. It is reported in 2026 SCC online SC.
This is on what ground you said?
My lord, prolonged incarceration, my lord.
Okay,
On prolonged incarceration or delay in trying as well.
Hmm.
On para 12 to 14, my lord. 2026 SCC online SC 1657, my lord. Para 12 onward, my lord. Further, the contention raised by Ms. Goswami that the petitioner has been suffered prolonged incarceration nearly of 3 years without any substantial progress in the trial. But here in this case, trial was not progressing, has not been impressed us. The investigation in this case has completed within 3 months of the FIR registration. It has indeed been less than 3 years since the petitioner liberty has been curtailed, but one cannot lose sight of the fact that the trial has commenced. The mere fact of the petitioner having been incarcerated for nearly 3 years or likelihood of trial not concluding within a reasonable period would not by itself entitle him to be released on bail, giving the gravity of the offense alleged and the possibility of witness being influenced and the evidence being tampered with. 13. Nevertheless, we are not oblivious of the petitioner right to a speedy trial. Having taken note of the concern expressed by the respondent state that since the prosecution case rests on the circumstantial evidence and having regard to the fact that the testimonies of the vulnerable employee witness and associate are highly sensitive and crucial, which need to be recorded without any taint, we encourage the relevant session court to make sincere endeavor to have a testimony to the following 8 sensitive witness recorded out of turn, so and so, within a year from the date of communication of this order. This observation need not, however, be understood as to require session court not to record the testimony of any other witness in the meantime. It shall be open to the session court. And this is the direction. And my lord, the on 14 liberty has been granted, my lord. On after recording of the same, the court they can approach for the grant of the bail, my lord. So, my lord, in this case, in our present case, my lord, the trial is progressing, my lord. This is not a case where trial is not progressing. And my lord is well aware of the X versus Rajasthan case also, my lord, wherein it has been explicitly held that, my lord, if the prosecution has started examining the prosecution witnesses, then court should not, in my lord, interfering or entertaining the application of, my lord, bail. Only in the case where there is no any, my lord, default on the part of the accused, then court can take it into consideration. But in the present case, my lord, there is neither default on the side of the prosecution also. In fact, there is no any default as such. My lord will find in the discussion made by the coordinate bench also, my lord. The trial is progressing, my lord, properly in its own phase, my lord. It's progressing. So, my lord, there is no any possibility of trying being delayed, my lord. And delay in trial itself cannot be a, my lord, even ground for granting bail, my lord. In this kind of cases, it's a 302 case, my lord. And my lord, so far as the statutory protection is concerned, my lord, it is also provided in the statute, my lord, that under trial prisoner, my lord, for how long the under trial prisoner can be kept in the custody. That is provided in section 479, my lord, wherein, my lord, the offense of murder doesn't fall, my lord. Section 479 of BNSS, my lord.
Okay.
That much, my lord.
Okay.
Well, I'd like to some of the arguments. So for some judgment is highlighted by those where the issues like when in ordinary circumstances when bail has to be granted, tempting, everything. I am not here on the merit of this. Basically, Article 21 of 226 judgment which has been relied by my lord has to consider that it says that the sensitive witnesses were yet to be examined. It's a completely different facts and circumstances, but that concession has been made by this apex court also. That right is always there, man. Article 21. That one. My lord has seen, my lord, since 1980 onwards, my lord. My lord, what happened? Otherwise, what will happen? If we say that Article 21, only procedure established by law, if we interpret this one, it will be something of era of 1975 emergency, my lord. That black history of judiciary that we say when the apex court failed to protect the fundamental right of the citizen, saying that during the emergency, people cannot approach the court for bail. This is a very unfortunate history on part of the judiciary itself. And let's say that later on, the part comes, my lord, that procedure is not only law. Procedure is reasonable, fair, has to be there. That should be humanly also, my lord. Procedure cannot be cruel also. This is where exactly our jurisprudence is. Thereafter, we are saying that, my lord, now issue before my lord, is it the contention of my learned friend that if a person is alleged to be a serious offense, then only law says that person can be killed. Then there is no bail, no procedure is to be reasonable. At any time they can go. No, my law is not that. No amount of justification can curtail this right once it has become unreasonable, unfair. That is it. Now, here is the case, my lord, has seen so far coordinate bench judgment, my lord, that bail has not been moved by this bail applicant. This is the first time bail application, my lord. Last time moved, my lord, this honorable court directed to approach. We approach, again we have filed this application. There only, my lord, has seen para 12, it says that because of the lapses of the prosecution, with due respect to the learned judge, my lord, that's my lord, it is not required that the lapses of the prosecution has to be demonstrated. I'm not there to show that because of the lapses, that not completing the trial within a reasonable period itself is the lapses, your honor. There, my lord, there cannot be any justification, my lord, if I read series of judgment from 1980 onwards, till 2024, even recently also, my lord. Then our own honorable high court, our own high court judgments, my lord. Series of judgments are there where it says that unless special circumstances is made up. Suppose that I am a case of my lord having a criminal tendency. I am a habitual offender. Likely, my lord, my releasing is likely going to commit again the offense, my lord. Then, my lord, of course, then it may be reasonable and fair to not to grant to detain me continued. But who am I here before? I don't have any criminal incident. I am basically, my lord, I am raising, my lord, a very young guy. I've even enclosed my certificate also, my lord. But even if my lord says that I am not 18 years more than my lord, but more than 20 years.
At the time of commission of offense, he was working, I think.
I was, my lord, I was in the tire shop. That's why, my lord, at the most, even my lord says that no, I was adult, which is a matter to be determined that I can raise that at any stage, even after conviction also, I can raise that issue.
Yes.
I will do that part. But here, my lord, now, no criminal background, no antecedent, my lord, happens, circumstances are there. Of course, my lord. There is a circumstantial evidence against me of being involved. But that itself is not sufficient that all the other aspect has not to be looked into. Well, comparatively, my lord, apex court has granted bail. In very infamous case, comparatively, my lord, comparatively, I am in a better position, my lord. With the person kills his own wife and pregnant wife, my lord. But
that is abatement.
my lord.
Okay. But here is the case. He practically he's the one who brought all those weapons, went out, brought the weapons from the scooty, and then brought here and used
I
it.
am not on the part of allegation. Whatever may be there, that
and then the conduct also is to be seen. Yes.
that part all over. Look, I am basically here only, my lord. That is it that reasonable? Article 21 my right violated or not? That aspect has to be considered.
Right.
Then that's why, my lord, all this aspect is saying that, my lord, that if you 5 years is not a kind of thing, my lord, and this has failed, my lord. That's why, my lord, otherwise it will amount to this procedure is not fair. It's not reasonable.
We should direct the government to appoint more district judge.
My lord, that's why, my lord, the state cannot have that luxury.
Trial.
My lord. My lord,
so the day-to-day evidence can be
state
explored.
cannot have that luxury that they will deprive our right. Of course, I am not saying balancing the right. Societal interests also there. Keeping me 5 years, getting all the exemptions, my lord, this has served the society.
That is true.
But where is the individual's interest in this all aspect? Because sometimes we look, because this is not exactly, my lord, my personal opinion. This is what exactly the constitution provides us. My personal opinion may be, okay, he has done something like he should be there. But I am here constitutional values, madam. I am representing here what our constitution says, our constitutional values. My personal idea may be different, madam. I may condemn it, my personal view, but my constitution provides it. Because we are a civilized country governed by the rule of law, whatever may be the allegation, all those things. Constitution protects this right to even a very hardest criminals to defend properly, to have a defense, to Because this, both the thing has to be there. Otherwise, if we go by only majority and society interest, then individual rights will not be there. But constitution first balances the thing where it is the fundamental rights. That majority ideas cannot infringe one person's right. This is what the fundamental rights are. And this is where, my lord, we are knocking the judiciary, my lord, that one right which is protected by the constitution has to be provided, protected. Society, of course, may say lots of things. This is my case.
Okay.
Obliged.
Mr. Rajesh, Sona, Land Counsel for the petitioner. Also heard Mr. Diete and additional PP for the state. Hearing concluded. Judgment reserved.
Obliged.
Item number 30, unlisted motion matter.
Okay. Unlisted motion. Why? Should have been the last item. Why you have come then? Why you have to mention?
That this is my first time. I thought that my one period would be
What?
whatever for me here in this honorable court. That's right. Because first time I have come here this bank on the first time, so that's why I'm come. Because in my career I have already 24 years running in this profession, but I got never scope to come here. So this,
Okay. Okay. What is your
my
case?
first case, therefore I have come.
First case?
This is my first in this court.
Okay.
Yeah, I'm suffering. My brother, I think, appreciate your lordship. So I am.
Okay. Okay.
I am
Please. What is your case?
My case is lordship. Here is the petitioner is the owner of a vehicle, my lord. He is not accused in that case. Apprehended person is the driver. The case has been registered under the NDBS Act, my lord. Now, your lordship, lastly on 14/6/2026, my lord, the vehicle was.
Bolemo PS case.
Yes, Bolemo PS case, my lord.
What is this 20B? What is this 20B?
20B, my lord. Cannabis was seized from the vehicle, my lord, as per information, my lord. Thereafter, my lord, what happened? You'll also kindly come to.
Just a minute. Huh? Produces, manufacture, process, purchase. Okay, this is cannabis. Two.
After apprehending.
Just a minute. Huh? Yes, where is the fire?
We could not annex the FIR, your lordship kindly come page 12, notice of.
There is 25 also. 25 also.
25 also.
Case has been registered under section 25 also, my. Your lordship kindly come to page 12, my lord, my petition. Notice under section 179 of BNS was issued to the petitioner, my lord.
Notice on the?
Under section 179 of BNSS.
What is that?
What is that? Where we are required to attend any person who is.
175?
179.
Where is that?
BNSS.
Page number 12, your lordship. Notice.
Notice is page number 12, type of law.
It's in Assam. Assamese.
Yes.
No, my lord. Page number 12, type of law. English. And the original copy of the Xerox is page 40. Your lordship kindly come page 14.
What is 179?
170 is police officer power to
Us-
pass.
Someone notice to appear, your lordship.
Notice for appearance.
BNS.
Yeah. But it is failed to comply with the notice, but there.
Why?
5 years.
Why he failed?
Yes, I. Paragraph 6, lordship. May kindly be paid, lord. Paragraph 6 of my petition. Because my lord, at that time, his wife has gave birth a pale child and mother also under treatment of the Mongoldo civil hospital, my lord. So under this circumstances, so he could not attend the police station.
When he was called?
On 10/8.
On 10/8, my lord.
Okay, but after also you could have attended. Why you did not?
Now he is willing to, but what happened?
Who prevented you if he is willing?
No, yes, lord. Now what
Who
happened?
stopped him?
Your,
Who stopped him going to police now?
yes, my lord. So now, my lord, he is willing to go to the police station, my lord.
Just a minute. You have not yet shown the FIR.
Lordship, FIR has not been annexed. FIR has not been annexed in the petition.
That is why he was avoiding.
Only notice is there, lord.
What is this page 10?
Is
Page 10 is the, my lord, regarding earlier what happened, my lord, the petitioner, my lord, the vehicle actually what happened, lordship, the vehicle was took by one Ramesh.
No, where is FIR? Just a minute.
Assamese was,
No, FIR.
no, my lord.
Have you reduced?
We could not annex the FIR, my lord.
Okay, then in that case,
Only one notice is, my lord. That was served by the police, my lord. Apprehension is that, my lord, he did not appear even at the time of serving the notice, my lord. The police asked his wife, my lord, to make assurance, ensure that he will appear on 10 August before the
you appear. You appear.
Therefore, at theatre, thereafter, now police is threatening over phone call that you come.
Yes, go.
Therefore, there is a apprehension, my lord. So, my only protection, my lord.
Where
I
is the
declare-
allegation? Where is the allegation? Allegation you have not. Annexed.
Section 25 is there, my lord. The case has been registered under section
20B1C.
the lord's condition registered under 20B.
1C.
Small. Yes, C. Capital C, and thereafter 25 of narcotic license. Therefore, my lord, the petitioner is before your lordship, my lord.
What is this? Mr. Jenny, what is this 20B? Okay, 2C, okay, not 1.
The vernacular basis.
Commercial. It's a commercial quantity.
it's a
Commercial.
commercial.
So only
Not be less than 10 years.
Yes,
Not
lordship, and
been less
extend up
than
to 20 years.
maximum 10 years, less than 10 years. my lord.
We need to peruse the case, this one.
Please, your lordship.
Yeah, FIR also. I need to see the FIR also, the allegation, how it was, from where it was found.
Yes, also I had just confirmed, your lordship, if page number 10 is a type copy of page number 11 or not. I'll just show your lordship.
We do not know.
Yes, I'll just show your lordship. I've just asked him if page number 10 is a type copy of page number 11, your lordship. If your lordship just peruse for a very small. At page number 11, it's written in Assamese, if your lordship will see it. Page number 10, if it's a type copy, your lordship will see that down below is the DLG PSGD number, your lordship. This is, he had filed, immediately it seems when he got the notice, he has filed a FIR before the concerned police station, your lordship. And they had not registered it, it's just in the GD number. There's just reported in the GD entry, your lordship. Now, if this is the type copy, your lordship will see the DLG PSGD number is Absolutely. In a type copy, it ought not to have been there, but the handwriting seems to be same, Your Lordship. Even we should ascertain if there was any file by the accused herein or not, because it was on 15/6, not registered. If the type copy.
Same day.
Yeah, same day, Your Lordship. If this is page 10 is a type copy, Your Lordship, of page 11, Your Lordship. It's impossible.
No, the
Completely impossible.
FIR was also lodged on the same day.
Yeah, it seems after he got the notice, he had filed an FIR about his missing car.
Kindly read the Assamese.
মাননীয় ভারপ্রাপ্ত বিষয়া মহোদয় দলগাঁও আরক্ষী বিষয়া, that means officer in charge of Dolgao. What happened, Lordship?
Read.
On 14/6/2026, Lordship, the vehicle was taken by 3 persons. One is Rameshwar Brahma. Here in
No, we need to see the FIR.
So when they did not, after taking the vehicle on here, they did not respond the phone calls, my lord. On suspicion, my lord, he filed that the vehicle has been misappropriated. Thereafter, he the petitioner my report the Dolgao officer in charge of Dolgao police station, my lord, and filed this FIR. That was DLG number, DLG means Dolgao Lordship, PS DLG number 9. As per information, police information. So after that, my lord, what happened?
Heard, Mr.
R. Hussain.
Learned counsel for the petitioner. Miss. Also heard Miss Ginny, learned additional PP, who submitted FIR. A copy of the FIR has not been annexed with the present bail application. She submitted there is also one FIR lodged by the petitioner regarding what?
Missing of
Missing of his
Wait,
vehicle
Missing measure.
on the same day. Stated to be lodged on the same day when the FIR was lodged.
No, when the notice was issued, Your Lordship.
Or not when the notice. That means FIR lodged
Yeah,
earlier.
earlier only.
Okay.
What I'm
When the impugn notice under 179 BNS was issued against the accused.
15/15 the notice was issued.
Therefore, she prays that the FIR need to be perused.
10/8.
Staff,
On FIR
and
clause
pray for some time.
15/8.
FIR need to be perused, and for which she
Yeah.
prays for some time to produce the FIR. Staff, the prayer is allowed. List the matter again on.
This, Your Lordship, it says this from West coming,
West coming district,
Okay.
Lordship.
Your Lordship may please this matter on.
She prays for some time to obtain instruction and to produce a copy of the FIR. Okay. The prayer is allowed. List the matter again on when?
11th, Your Lordship.
11th. Okay. On which date? Updated case diary along with the copy of the FIR shall be produced by the learned additional PP. Okay.
Deep.
Till then, my lord, protection,
No protection.
my lord, will appear there in person to the notice.
We
my
have
lord.
no idea. This is notice. Notice was issued on 11. FIR, we do not know when FIR was lodged. When the notice was issued to you,
Okay.
on the same day, you saw, on the same day, we have no idea whether you have received the notice on the same day or not. But then it appears that you have returned the missing of the vehicle on the same day when it was, notice was issued. Whereas on that day, when you received the notice, that time, this notice was not yet received by you. But then
Notice was issued on 7/8/2026.
7/8.
Yes, yes. Kindly come to page 14, Lordship. Lordship.
FIR was lodged on 15.
No,
14.
on
15.
our FIR was lodged on 15/6.
Okay. And then
And we got the
notice
from police station on 7/8/2026. Kindly come to page.
7/8.
Yes.
Okay. Then after receipt of notice.
Their FIR was the FIR.
After receipt of notice.
No, yes.
No.
No, Your
Before
Lordship.
receive of notice.
Okay. Just when you receive notice?
7/8/2026.
7/8/2026.
Yes, Lord.
Receive notice.
Yes.
Okay. When
We
you
lodged
lodge
the
FIR?
on 15/6/2026.
15/6.
Yes, Lordship.
And the other FIR which has not been annexed is also dated 15/6. The one they are seeking bail from your lordship, that was also registered on 15/6.
Okay. Okay.
On the
Better to
same
have
date
laws
when
on
the
that.
FIR was made against in this incident.
We
your
need to see the
lordship, he
DD entry
subsequently-
when it was.
DD entry, there's no date, therefore I was coming to that, you know.
No date. It has to be the, it
Yes.
has to have date.
This date is,
Date.
and there is no
Okay,
signature
let us
of.
confirm. Let us confirm. Don't worry.
Yes.
Okay.
So-
It was way back in June. You have not yet been arrested. Don't worry. You will not be arrested.
No, we will go and attend the police station, Lord. Therefore, my lord, till the my lord case diary is come, my lord.
See, this was issued on way back in June.
And we don't know the content, your lordship. It's just-
So since June, you did not attend. Police has not arrested you. You are expert.
Yes,
Don't worry. Look,
Deep.
Item number 13 and 14 is a passover matter.
When did the date given?
11 September.
September.
11 is what? Friday.
Friday, your lordship.
Last day. That falls on last day.
In that case, 15, your lordship. 15, your lordship.
Last day would not be a good.
On 15.
Okay. 15 or 14 or 15. Okay. 15, huh? Planning Council, it's 15. Okay. Yes. Item. Okay. Yes. What is this 13 and 14?
Well, this is a criminal petition under section 482 of the Code of Criminal Procedure, madam. Here, madam, the petitioner is praying for the quashing of the FIR, madam. Quashing of the FIR, charge sheet, and the pending criminal proceeding, madam. And trial, my lord, yes, not yet commenced, my lord. CC is yet to be framed in this particular case, madam. Basically, this case has arisen out of that, my lord, when the relationship, very often kind of relationship, like living like a husband and wife only for almost 7 or 8 years.
But then it was a state.
State, that's why, my lord, no charge is yet.
Yes. But then why don't you take liberty to file discharge petition?
My lord, that is
Because see, the trial of the case cannot be stalled for the indefinite period, and then unless we cannot appreciate the evidence.
no,
The High Court.
not on the evidence, my lord.
No. See, how do we appreciate unless the trial court here on the matter on the charge, question of charge.
Here, my lord, why I am before my lord? My lord knows 482. Filing charge sheet, pendency of trial is not a far. The question, the scope under 482 is only the thing my lord will be looking on the allegation as it is, without the allegation of the prosecution as it is, taking it on its own face value. Whether there is a prima facie criminal case
No, see.
for the trial. This is, my lord, generally in all the cases for quashing, this is how, my lord, scope of.
See, here the allegation is different, 376.
That's why, my lord, writing 376, but
That
see, what is the allegation? Can we say 370? Because plenty of judgments, then when the consensual relations is there, madam.
At a time of hearing on the charge, see, only the prima facie is to be seen. So thereafter, after you have take a liberty to make one small application for discharge. So at the time of the hearing on the discharge, supposing the learned trial court failed to appreciate your argument, okay, your contention that there is no prima facie case, and then fail to appreciate that, then and reject your application for discharge, then of course you can come that this is the fact and this has not been appreciated, and then otherwise there is no case.
That is always there, madam. That is always there. But 482 is the procedure, basically in most of the cases. When The case, there cannot be any case. The question of why should a person should go to the criminal court? Why should a person should be made an accused? Why should he face the trial? This is the whole reason of for it.
But this is not a case of consent, not a case of
Not required
the-
consent, my lord.
Mm.
I will, so, my lord, plenty of judgment.
because the other side is contesting the case
That's right.
and says that there is an allegation.
My lord, I understand.
Ah.
But basically, my understanding of the law
Yes.
482, my lord. Basically, my lord, I'm praying, my lord, that look, these are the allegations against me. But this allegation taking in its own face value, whether the case is there that one should go to the even FIR should have been registered, whether charges should have been filed, or other one I should go to the trial court praying for the discharge of the case. This is basic. My lord. That part is different. If my lord says that no, there is a case on the taking in its own value.
It's under IPC.
My lord. IPC, my lord.
317 is also there.
My lord, yes, my lord. Very interesting, my lord. My lord, now settle law series of judgment letters, Supreme Court judgment is saying that whenever a girl and boy, adult, is living together openly, relations, there is always presumption that relation is consensual. Later on, for some reason, whatever it may be, the complainant will have different version, I will have a different version. Bone of contention may be different. But subsequent breakdown of the relation or not culminating into the marriage, my lord, that cannot be the basis for filing criminal case, my lord. This is a settled principle. On that basis, my lord, I will be arguing my case. Because, my lord, there is no case. What is the allegation there in the FIR? This is no case. I will substantiate with, if my lord.
Just a minute, huh?
Yes,
The allegation is, where is the FIR? Say?
my lord will file FIR.
What is this amendment?
Amendment, my lord, some prayer, because when this criminal petition was filed, at the time only FIR was registered, investigation was under pending, my lord. And thereafter, my lord, during the pendency of the criminal petition before this honorable court, subsequently charge sheet was filed. Therefore, my lord, just prayer portion saying that I want that quashing of the charge sheet along with entire criminal proceeding.
They have received the amended petition.
Yes.
Okay. Has it come on record?
My lord, I have filed.
Okay. File means the learned counsel for the petitioner has to file an amended petition as the direction to receive. Okay. Just a minute, huh? The FIR is it? Okay. So, as per the FIR, according to you, there is no prima facie case
No case, my lord.
for offense.
Yes, my lord.
And 376, 317 is also there. Okay, 420 is there.
Yes.
It's a question of promise.
That's why, my lord, it's only section is included, but there is no like materials to say that these sections can be accepted.
Okay, yes, false promise. There is an allegation of theft also.
Theft, my lord, when, my lord, that's why it cannot be. When I am living, my lord, together as a husband and wife, my lord, if I take something, my lord, can it be say that theft is like when both the person is living together as a husband, wife, my lord, and in possession, joint possession of the thing, cannot be said. So behind, my lord, 482 object is that
I think there is some allegations.
demonstrate, my lord, that the entire reason why criminal proceeding has been initiated.
First, let us just read in the FIR. Okay.
FIR, very lengthy FIR. Just
yeah, it's lengthy.
Yes, very interesting FIR.
Interesting also.
Yes, my lord. From its own FIR itself, it shows that this is something like ultimately intention is to grab the property.
Okay, the accused is the police.
He was serving as the sub-inspector at that point of time.
Now,
Now
inspector.
he's a inspector, I think, posted.
No, when they're serving as inspector only.
Yeah, at that point of time.
Hmm.
Yes, ma'am. So should I read my note or?
Just,
Yes.
no problem. No need to read. Just read yourself. Because there is an allegation. No need to read. Just something. Okay. Misrepresentation of promise of marriage. It's the living together consent is subsequent, it appears. But an initially allegation is misrepresentation of promise of marriage.
That's
Otherwise, later on, it appears that later on being convinced that he is not a married person, then of course, consent, living together, everything is there. That seems consent, but then initial allegation is there.
That's why, my lord, this kind of issues has been dealt with by Apex Court in also. Has been also saying that when you are subsequently, after knowing all the facts, suppose assuming once he is saying right for a while, so all the things also that you have been continuing the relations, 4, 7, 5, whatever.
So the initial
question,
so the initial
presumption automatically heavy presumption will be there that from the inception itself that was a consensual. Had it been the case, my lord, once I came to know, suppose initially, suppose a false promise has been made. Once I came to know, thereafter I immediately lodged the FI. Then I thereafter don't maintain the relationship. Matter would be different.
So see, it continued for years together without knowing.
No, my lord. She even came and met my first wife. And she said that when my first wife said no objection, then she started continuing relationship with me, my lord. So she used to visit my house also and used to meet my wife also, first wife.
No, then after coming to know that she has a serious confrontation.
Yeah, my lord, that is there.
With him, decided to leave, but then kept on tracking. Thereafter also you started, you kept on chasing. So it appears that being a police, he had a device to locate also, it appears. That is what the allegation is. Okay. You see. But she has given a sequence also that thereafter, when she came, she confront and then gathered courage to meet his wife also. So the sequence is coming in that way. But then it appears that in the beginning, she had no knowledge. Okay, then wife also fine. Have you seen the chart sheet?
Not yet, Lordship. Lordship is here.
Any implication?
Lordship, here, Lordship, in the chart sheet, Lordship, that is their Lordship, that material is their Lordship, and that's why Lordship 376 and 420 and 506 is booked, Lordship. It's in the chart. And also, Lordship, moreover, Lordship, in the trial, Lordship, it is state Lordship because this court has state depositing. That's why, Lordship, the trial could not be proceeded any further.
See,
Otherwise, Lordship,
yeah, in such cases, probably, Councilman, Mr. Rajesh. So in such cases, when there is a confusion, may or may not be. Here, I think it's better to take opportunity to cross-examine, to demolish the evidence of the petitioner. Because the allegation is clear, whatever may be circumstance, we cannot, of course, on assumption and presumption, because both were major and she knew it, okay, even that also. But then there is allegation, even if we know that she knew it from the very beginning, but then there is an allegation, which she probably has reiterated and consistent in her statement. So under the circumstances, so when she is contesting, and then there is a material which, of course, unless there is a cross-examination, cannot be demolished, cannot be rebutted. It can be rebutted only during cross-examination. But then, of course, you can take one chance. As I'm saying, that during the time of framing charges, if the court doesn't find enough material to frame charge against you, that's well and good. But then if there is certain, because here we cannot, High Court cannot throw that. We can go through only to the extent what you submit, that if there is no evidence. But then this evidence from the face of the FIR, there is an allegation. What is to be satisfied is that there is an allegation.
Allegations be there, no doubt. But my case is that whether taking this allegation on its face it, because writing, that's why this 482 power is there.
That I know.
That writing, making allegation, something only just writing in the paper is not sufficient. Overall, my lord, probability has to be seen, my lord. Whether this kind of allegation, any probable person will believe in this kind of allegation. This is one factor where quashing can be, power can be exercised. But our own High Court also.
Yes,
there are numerous.
yes, that is there. That is there. But that is in case of where, of course, absolutely where there is no material, and in the case where there is consent, in the case where there is a settlement. But here is a case where it is a contested, and then the allegation is reiterated, and then she is consistent, and then there is some material. And then here you see, here is the case where the allegation is made to a person who was already married, and the allegation is made by the person who is not yet married. And then this is the one person to whom she believed initially. And then later on, subsequently, of course, it came out to be, of course, the wife also have no problem having second wife. But then she struggled thereafter, after coming to know.
Our consistent approach, judicial approach, and judgment is that when the two adult person being in living relationship for a sufficient number of time, plenty of them. Thereafter, if tomorrow relationship could not be terminated with the marriage,
that is different.
This is this.
But here the case where allegation is as such
This
that
is the case, by the way.
on the false promise, see that he was not married. You had remember.
False promise.
It is assumed that she consented because he promised. He says that he was alone. He is not married, unmarried. With the belief that he will marry.
That initially, that is that definitely her version. Let's assume that is there. Now question is that under that circumstance, it is her own case. She went, met my wife, first wife.
That is later on, after years.
Yes, that's why. Then she met, thereafter she continued that relation. That itself is sufficient to show that.
This is subsequent.
My lord, suppose now, under what circumstance, suppose initially, can we believe in this statement? Suppose a girl, suppose she has been misled by making false promise of marriage, single. Tomorrow, suppose I come to know that he is married. What should be the appropriate way? Is to immediately file the FIR, then not to maintain the relations. But here, this is not the case. Then matter would have been different. On coming to know.
Here, you are right. 376 ultimately may go. but then cheating again will remain.
Cheating also, my lord,
Ah.
I see from
Ultimately, because
from the-
376,
my lord,
because,
from the
because
entire-
both were major.
my lord, from the entire these things, my lord. That's where from the entire this thing, my lord, cheating also is something. False promise and breach of promise, my lord, there is a difference. My lord. My lord, that my intention, my lord, can see. My lord, there is nothing to show that from inception I had a bad mind. Our intention is to living as a husband and wife. We wanted to have child also. This is very clear. My lord. I wanted to have a life with her. Right? My lord, since my wife also allowed me, I'm living as husband and wife, there is her own.
See, the intention. No, she conceived, but then ultimately gave medicine and 3 times miscarriage. So the intention, it appears, has been shown that he had no intention to actually marry.
Now, finally, this year, we have again decided to conceive, accordingly met the gynecological. Now, currently also, at the time of filing ever also, my lord, we were visiting the gynecology, my lord. My lord, so to say, my lord, I really, my lord, another factor, my lord, another issue. I purchased the land in her name even. I wanted to really settle with her. But subsequently, this is the reason, my lord. When I found her, like, she is not like she doesn't want to stay with me. I found her like going around. Then, my lord, I had to decide, my lord, that then I took it back my land also. And that's why this case is.
Lordship, just a small prayer. Since item number 13 is my IA may be hard first, because I'll make the fact clear, and then
what clear? How you will clear it?
on the face of record itself, because PCR is there, Lordship. I'll confine only to the PCR, what is on the record, trial court record. Nothing more than that. I'll not go beyond.
Yours is for vacation.
And mine is for vacation because, Lordship, this has been pending since 2024. After the court, Lordship may see the interim order.
No.
There is no reason as
Since the record is there, instead of hearing the vacation, we'll have the entire matter heard.
Yeah, that was the understanding arrived. However, if it, in case, if it cannot be taken up together, then this is my humble prayer.
Then I will file objection to the IA, my lord. Only because of that understanding only I have not filed. If he's insisting, give me some time, at least 2 week time, I will file objection to IA. Then I will have.
I think we'll then what we'll do.
Argument on IA first then.
Also, that was the understanding. I am ready for entire matter because there is series of 3 times already this court, honorable court has granted us for final disposal because the matter has been stayed since 2024 and the IA I have furnished. And in the last occasion also, honorable court has categorically observed that if the entire matter cannot be disposed of, then the IA shall be heard. It is on the record, Lordship. So that was the understanding arrived between the parties. Therefore, I'm.
No, just a minute, huh? So just to have some idea, what you wanted to show from the TCR?
Lordship may, the TCR Lordship, they have brought the charge sheet by way of additional affidavit, which is with me.
Charge sheet, okay.
This is, I think like, this is included in the TCR. As Lordship.
For what is there to show there is a prima facie case against?
Lordship, he has gone to the extent, to that extent, because Lordship,
What extent?
my learned advocate is harping only on 376. I said there are several other matters also. He has gone to that extent. When
No, that is subsequently, see.
No, on forgery of the document. I'm submitting on that.
Forgery is registered? Has he been also charge sheeted?
Initially, yes, it is in charge sheet. It's they have brought on the record.
No, where is the operative portion of the charge sheet?
Lordship,
Forgery is also there.
yes, in the additional affidavit because initially the case was registered under only 3 sections. Subsequently, after this honorable court has directed Superintendent of Police Itanagar to supervise and monitor the investigation, and after carried out detailed investigation, they had under the supervision of Superintendent of Police Itanagar.
Okay, then I think because there is subsequent complaint is also there. So I think it will take some time to.
My lord, that's why, my lord, my learned friend is also saying about this forgery, all those things, my lord.
So it
My lord,
appears
this matter may be fixed on 14 for final disposal, madam.
there is other
Because also that
there is subsequent
dragged for
there is subsequent complaint also, isn't it?
so that has not been registered because he was, that is my submission because
Okay, that is
bad intention, dishonest intention since the beginning.
okay.
Lordship, just one their additional affidavit wherein charge sheet has been brought. I only page number 8.
Of
Page number 8.
8 of
Page number 8 of their additional affidavit. This
additional
is a charge
affidavit.
sheet because they have brought the charge.
Additional affidavit filed.
Additional affidavit filed by the
Additional or amendment?
amendment is subsequent. Earlier, they have filed additional affidavit.
Page 8.
Page, the charge sheet is searched from page 4.
Okay.
Page 7. Page 7 is during the course of investigation.
Okay.
Lordship, I'm just reading the operating portion. It is page 7.
Oh, page 7. Where?
Page 7. It is pertinent to mention that here that initially the case was endorsed.
Where are you reading?
Page 7 during the course of investigation down. It is pertinent to mention here that initially the case was endorsed to an investigation.
During the course of investigation, the previous investigation officer.
No, I just want to show how this has been asserted under the supervision of Superintendent of Police, Itanagar.
Where do I find line?
During the course of investigation, may I read that?
Yes.
It is pertinent.
Okay, the headline. Okay, it's in the middle. Okay, I told that last pen. Last also during the course of investigation, the same thing is there.
Oh.
Okay.
Which is in the bold.
Okay, board one, okay.
It is pertinent to mention here that initially the case was endorsed to and investigated by Inspector Mitch Rupa. And later, after the order dated so and so passed in case number so and so, in respect that this was the anticipatory bail because they had filed anticipatory bail. And while granting anticipatory bail, this order has been passed in respect of so and so process by the Honorable Gauhati High Court Itanagar Permanent Bench, UPA, wherein the said Honorable Court has directed the Superintendent of Police Itanagar, Captain Complex, to personally monitor and investigate of the proceed case, thus the instant case has been handed over. So this is only to show that this is not the case simpliciter.
Okay.
This has been
Okay, let them file objection.
so this has been
But the next date is in the month of December. So my friend even get it vacated, nothing will happen, my lord. It's in the December CC fixed, my lord. By that time, I think
CC fixed already?
yes, it's fixed on appearance. December.
December.
Yes. One,
So my prayer, my lord, this.
Okay, so what we'll do?
Lordship, only one more submission, only one more submission.
I think you file objection, but then ultimately the interim has to go. It appears.
My lord, that's
Because
why-
we
that-
cannot,
that's
it cannot,
after
it
hearing
cannot be
me.
permanently
Yeah,
stalled.
after hearing me, my lord.
Mhm.
Thereafter, that's why. my
Yes,
lord,
yes, you file objection.
that entire matter can be, because piecemeal, if I argue for the IA, definitely it will cover entire case. my lord.
Yes, yes.
So there is nothing. my lord.
Almost.
Yeah, IA will be safe. Therefore, my lord, my prayer, my lord, this.
No, Lord, that was the understanding because they were of the opinion that they will not file objection. Therefore, the Honorable Court was
21, my lord, 21.
And Lordship,
This month of
one
21, my
point, Lordship, page number 9 of this.
It's okay because in any case, since we are giving an opportunity to file objection, let him file objection. Okay. Mr. Marco, Lana Council for Lana Council for the applicant. Also had Mr. Oh no, Miss. Hage,
For state lawsuit.
okay, for additional PP for the state respondent and Mr. Arsona for the respondent number 2 staff. Where Mr. Sona, Lana Council, appearing on behalf of the respondent, a private respondent, seek some time to file objection. The prayer is allowed. Staff list, staff is requested, list the matter on 21.
21, my lord.
21 is
Monday.
Monday, okay.
Item number 18.
Much. My lord, this instant protection that may be continued.
Okay, the interim, okay, in the, it is in the main, okay. Main had Mr. Arsona, Land Council, for the petitioner. Also had Al Hage, an additional PP for the state, and Mr. Arkoyo for for respondent number 2. Staff, as requested, list the matter again on 21. Yeah, in the meantime, the interim order passed earlier shall continue till then. Okay.
My friend was referring one order where the direction given for the superintendent of police going to.
Hmm.
I was granted by the benefit of pre-arrest, where in 376, considering the nature of allegation in the FIR matter. By this honorable court only, madam.
May I pray that Lordship endeavors
Just to, madam, there was so many objections. Just to seeing this honorable court, just to take care of the interest of the.
Here, of course, the the possibility is 50-50.
Deeply on that, madam.
May I pray that
Okay, in IA, on which stage, and endeavor shall be made to dispose of this IA, okay, dispose of the IA. Okay.
Item number 18.
18 for referral. None appears. On behalf of the parties. list the matter again next week. Okay.
Item number 19.
Yes. So it's for referral to the,
Yes, sir. Yes, boss.
okay,
We are ready for.
ready?
Yes, sir.
Okay. Add Mr.
A Gamre.
Islamic Council for the petitioner. Also heard Mr.
T Taggu.
for Islamic Council appearing on behalf of the only sole respondent.
Yes, sole response.
Sole respondent. Stop. Huh? The matter is listed today for consideration of its consideration of the matter, consideration of its referral to the mediation and the special mediation drive, this mediation for the nation. Staff. Islamic Council for Islamic Council appearing on behalf of the parties submits that there is element of settlement of the matter and therefore the dispute may be explored through mediation. Okay. Yeah. Not necessarily. Through mediation, no? Oh, stop. Huh? Considering the nature of dispute and the possibility of amicable settlement, this court is of the view that the matter deserves to be referred to the mediation. Stop. Huh? Accordingly, the present civil revision the present civil revision case is referred for settlement. Stop. Huh? Settlement through mediation. Stop. This is more like same only. I have actually dictated earlier. Referral. Similar. Then the registry is directed to place the matter before the mediation and transmit the relevant record of the case before the mediation center for the purpose of conducting mediation proceeding. Stop. The parties shall appear before the mediator on the date and time as may be fixed by the mediation center. Stop. The mediator shall submit a report of mediation proceedings to this court upon conclusion of the mediation. Stop. List the matter after receipt of the report of the mediation proceeding. Okay.
Much. Item number 20.
20, Lordship, I am for the petitioner.
Okay.
I am ready to be for this matter to be referred to mediation, but it seems the other.
You inform. We'll try to explore next week. Okay. You are for the petitioner.
Yes, yes, yes.
Okay. Mr. Ramde, Planning Council for the petitioner is present. However, none appears on behalf of the respondent. In view of the above, list the matter again next week. Okay.
Item number 21.
21. None appears on behalf of the party. List the matter next week.
Item number 22.
Where is the other party?
Lordship, service is still not done.
Okay. Oh, service not yet come.
Not yet done.
Okay. Mr. Lawrence, Planning Council for the petitioner. The office note dated 29/8/2026 reflect that the service of notice upon the respondent number 1 to 12 is still awaited. In view of the above, list the matter. When do we list it? Next week? Not possible.
Not possible.
After 2 weeks. Okay.
After three weeks.
After 3 weeks. Okay.
In the meantime, Lordship, interim order.
The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply obliged.
Item number 23.
True. You're ready? Otherwise.
Lordship, for the petitioner.
Okay.
TCR is still awaited, Lordship.
Awaited.
Yes.
Okay. The Mr.
D. Tali.
Planning Council for the petitioner. The trial court record. Who appeared for the other side?
Deloy.
Hmm?
For other side, Deloy. PP.
Oh, PP?
Yes, Lordship.
There is no private. This is a question petition.
Yes, Lordship.
It's a consent only. The trial court record is still awaited. In view of the above, list the matter. Which court? Where is PP? ADPP. List the matter again next week. Okay.
Lordship, kindly after 3 weeks.
Why?
Or till the returnable date of TCR, Lordship.
Which court actually is this matter is pending before which court? Yeah, only. It won't take much time. Let us see. What is the allegation? There is a consent. Both party settle the matter.
No, Lordship.
It's a contested case.
Yes.
Who contest against you?
Lordship, I don't have the knowledge of the brief.
It seems.
Yes.
Because there is a agreement. Just a minute.
Yes, Lordship.
Because both the council there is no agreement. You have not met the respondent as a sorry, the informant as a respondent party. Probably you may have to. Direct counsel, you have to, I think, implead the informant. Okay. Mr.
Ditali.
Direct counsel for the petitioner, stop. The Direct counsel, the Direct counsel for the petitioner submits that inadvertently the informant has not been arrayed as impleaded and arrayed as the party respondent. Stop. Therefore, he requests, he prays that we may be allowed to implead the informant as a respondent party. The prayer is allowed. Stop. The petitioner may is permitted to file amended course title by the file amended course title for implement. File appropriate application for implement. Okay.
Lordship,
You have to implead the respondent.
yes, ma'am.
Informant first.
Yes, ma'am.
You have not impleaded.
Yes, ma'am.
Okay.
Lordship, there is an interim. Kindly, it
Okay,
may
the
continue.
interim order pass adia shall continue till the next date of this thing. Okay.
Oh, yes.
List the matter after 2 weeks.
Item number 24 and 25.
Okay.
May I please, my lord?
Yes, you are for?
I am for the petitioner, my lord.
Okay, what is this?
In my lord, we substitute the name of the my lord respondent, my lord, because during the pendency of this civil revision petition, the respondent was expired. So in her place, her husband may be implemented as a respondent.
In CRP?
Yes.
Okay. Hard, Mr.
And Sura.
Direct counsel for the applicants. It is submitted that during the pendency of this the civil revision petition number 17 AP 2018, the husband was respondent number,
Sole respondent.
the sole respondent. What's his name?
My lord, Nyagogi.
Nyago Gay.
Yes.
Expired.
No, Nyagogi is husband, my lord.
Who expired?
His wife.
Who is?
Gautam Gay. Gongam Gay. Gautam Gay, my lord.
Gautam Gonga Giri was
expired.
Gay was the respondent.
Yes, my lord.
Okay. The sole respondent Srimati Gautam Gangam Gay expired, passed away on. Have you given the date?
No, my lord. Exactly. We are not aware of that.
You have no information.
Yes, my lord. Just we are informed that he was expired.
Stop. By filing this interlocutory application, the applicant, petitioner, who is seeking substitution of the name of the respondent, let Gautam Gongam Devi by her husband. Gautam Gongam Devi, since deceased, by her husband, Sri Nyago Devi, as respondent in CRP number 17 AP 2018 staff. Upon consideration, the prayer for substitution. The prayer is allowed, staff, accordingly. The prayer for substitution of sole respondent let Gongam Gay, since deceased by her husband, Sri Nyago Gay, is allowed. Stop. With the above, this IS stands allowed and disposed of. Okay, in main, huh? Yes. Mr. His name, huh? Planning Council for the petitioner. Stop. Huh? In view of the order passed today in IA 91, IAC 91 AP 2026, comma, the Sri Nyago Gay, huh? Is impleaded as sole respondent in place of her wife, late Gautam Gangam Gay, since this is stop. The petitioner is allowed. Petitioner is allowed to amend the co-statute by inserting the name of the newly impeded respondent Sri Nyago Gay as respondent. You amend the co-statute, okay? Okay. Within 2 weeks. Least a matter after 3 weeks. Okay.
Diplomates.
This is 24, 25. Okay, that's all.
Lots of.
Okay. Hmm.